Right to Life group. Welcome. She is our Wood County representative and a very unique lady. I hope she's in the gallery. Please, if you're here, Miss Patty
Kim, welcome.
The gentleman from 22nd, Doug Moffett.
Thank you, Mr. Speaker. In the South Gallery, we have a friend from Hamlin. So on behalf of myself, Delegate Hornbuckle, Delegate Miller, Delegate Morgan, and Delegate Eldridge, please welcome back to the Capitol Larry May.
John from 17th, Delegate Reynolds.
Thank you, Mr. Speaker. On behalf of Delegate Rohrbach, we have a constituent today from the 17th District. Would ask Mary Gill, who's an AARP volunteer, to stand. She's in the South Gallery, and the housemaker welcome.
Delegate from the 37th, Delegate Pushkin.
Thank you, Mr. Speaker. We have joining us today in one of these galleries, I hope, folks from the West Virginia Association of Alcoholism and Drug Abuse Counselors, and they're out in the hallway, and they're giving out these little people that are supposed to represent a real person, and they have names on them. Some of the names represent people who have died because of the disease of addiction. Some represent names of people who are actively in recovery from addiction. And some also represent names of people who need treatment and are currently trying to get into treatment centers in this state. So if the folks from the WVAADAC are here, if you could rise and please make them feel welcome.
Gentleman from the 24th, Delegate Rogerio.
Thank you, Mr. Speaker. On behalf of the 20th, 21st, 22nd, and 24th District, we have some pages from Main High School. We have a Brandon Cook, Catherine Curry, Autumn Copley, Casey Carter, Jada Harris. Would the floor please make them welcome? Thank you.
Gentleman from the 19th, Delegate Hicks.
Thank you, Mr. Speaker. I'd like to welcome 3 pages from District 19, Wayne County, and those are Luke Wells, Matthew Wells, and Samantha Wells. And they are escorted today by my wife, Tanya Hicks, and their mother, Jeremy Wells. Please make them feel welcome. Thank you.
John from the 19th, Delegate Perdue.
Thank you, Mr. Speaker. From Wayne County, where the sun shines latest in West Virginia, once again, I have my good friend, AARP volunteer advocate, Mr. Herb Muncie. Herb, would you rise? And I'll ask everybody to give you a fine welcome.
Lady from the 43rd, Delegate Campbell.
Thank you, Mr. Speaker. On behalf of Delegate Hartman and me from the 43rd District, from Pocahontas County, we have 2 very special pages with us today. We have Ty Cochran and Alan Gibson. They are in 7th grade and they attend Green Bank Middle School. And if I'm not mistaken, they are also Boy Scouts as well. They are accompanied by Sam Gibson and Brenda Cochran. If the House would please make them all feel welcome, and if the parents will stand in the gallery so we can acknowledge you.
John from the 16th, Delegate Hornbuckle.
Thank you, Mr. Speaker. Today I would like to introduce my intern from the Fraser Singleton program. With us today we have Cheyenne DeBolt. She is a double major, political science and public relations from the Marshall University. Body, please make her feel welcome.
John from the 58th, Delegate Coles.
Thank you, Mr. Speaker. Ladies and gentlemen, joining us today for the Doctor of the Day program in the back of the chamber, we have with us Dr. Carolyn Curtis of Huntington. If the House will make the good doctor welcome.
Further introductions. Reports of standing committees.
Committee on Industry and Labor has had under consideration House Bill 4321 relating to tax credits for apprenticeship training in construction trades. Reports the same back with the recommendation that it do pass, that it be referred to the Committee on Finance.
Report be received and the bill be referred to the Committee on Finance.
Committee on Education has had under consideration House Bill 4465 relating to salary equity among school systems. Reports the same back with recommendation that it do pass, that it be referred to Committee on Finance.
Report be received and the bill be referred to Committee on Finance.
Committee on Education has had under consideration Committee Substitute for Senate Bill 146 establishing instruction standards for early childhood education, and Committee Substitute for Senate Bill 369 reducing legislative education reporting requirements. Reports the same back with amendment with recommendation that it do pass as amended.
Report be received.
Committee on Government Organization has had under consideration House Bill 4359 requiring the issuance of a photo identification to persons employed as a security guard by a security guard firm, and Committee Substitute for Senate Bill 309 relating to child care center licensing and exempting county parks and recreation from licensure. Reports the same back with recommendation that each do pass.
Report be received.
Committee on Finance has had under consideration House Bill 4150 making a supplementary appropriation to the Department of Health and Human Resources, House Bill 4151 making a supplementary appropriation to the Department of Education, and House Bill 4159 making a supplementary appropriation to the Public Services Commission.
Report be received.
Committee on Finance has had under consideration House Bill 2474 relating to the compensation of personnel employed at the West Virginia Schools for the Deaf and Blind, and House Bill 2852 relating to legalizing and regulating the sale and use of fireworks. Reports back committee substitutes, therefore, with recommendation that the committee substitutes do pass.
Report be received.
Committee on Judiciary has had under consideration House Bill 4013 requiring a person desiring to vote to present documentation identifying the voter. Reports back committee substitute, therefore, with recommendation that the committee substitute do pass.
Report be received.
Committee on Judiciary has had under consideration House Bill 4213 Uniform Deployed Parents Custody and Visitation Act. Reports the same back. Reports back a committee substitute, therefore, with recommendation that the committee substitute do pass.
Report be received.
Committee on Judiciary has had under consideration House Bill 4053 Department of Environmental Protection Air Quality Rule relating to the control of annual nitrogen oxide emissions. Reports back a committee substitute, therefore, with recommendation that the committee substitute do pass.
Report be received.
Committee on Judiciary has had under consideration House Bill 4499 relating to certain persons who have been disqualified or excused from jury service. Reports the same back with recommendation that it do pass.
Report be received.
Committee on Judiciary has had under consideration House Bill 4261 prohibiting the sale or transfer of student data to vendors and other profit-making entities. Reports back to committee substitute, therefore, with recommendation that the committee substitute do pass.
Report be received.
Committee on Judiciary has had under consideration Committee Substitute for Senate Bill 150 authorizing Department of Transportation promulgate legislative rules. Reports the same back with amendment with recommendation that it do pass as amended.
Report be received.
Committee on Judiciary has had under consideration House Bill 4520 clarifying that certain hospitals have only one governing body whose meetings shall be open to the public. Reports back committee substitute, therefore, with recommendation that the committee substitute do pass.
Report be received. Reports of select committees. Messages from the executive. Messages from the Senate.
The Clerk of the Senate announced that the Senate has refused to recede and requests the Committee of Conference of the two houses on committee substitute for House Bill 2800, adding law enforcement officers' contact information and names of family members to the list of exemptions from public records requests. Senate appointees are Senators Ashley, Carnes, and Wolfle.
Gentleman from the 58th.
Thank you, Mr. Speaker. I move the House agree to appointment of a committee conference of 3 from each house on the disagreeing votes of the two houses, and that the Speaker be authorized to appoint a conferees on part of the House.
The gentleman from the 58th moves that the House agree to the appointment of a committee conference of 3 from each house on the disagreeing votes of the House, two houses, and that the Speaker be authorized to appoint conferees on behalf of the House. All those in favor will say aye. Those opposed, no. The ayes appear to have it. The ayes do have it. Declare the motion adopted. On behalf of the House, Chair appoints the gentleman from the 38th, Delegate Lane, the gentleman from the 33rd, Delegate Hanshaw, and the gentleman from the 52nd, Delegate Schaefer, as conferees on behalf of the House. Further messages.
The Senate has passed Senate Bill 299, creating Library Facilities Improvement Fund.
Message be received. The bill will be referred to the Committee on Education and then to Finance.
The Senate has passed committee substitute for Senate Bill 328, creating West Virginia Veterans Program Fund.
Message be received. The bill will be referred to the Committee on Veterans Affairs and then to Finance.
The Senate has passed Senate Bill 403, relating to cooperative extension workers.
Message be received. The bill will be referred to the Committee on Agriculture and Natural Resources and then to Government Organization.
The Senate has passed committee substitute for Senate Bill 404, removing prohibition on billing persons for testing for HIV and sexually transmitted diseases.
Message be received. The bill will be referred to the Committee on Health and Human Resources and then to Finance.
The Senate has passed Senate Bill 459, requiring County Board of Education to pay tuition to Mountaineer Challenge Academy.
Message be received. The bill will be referred to the Committee on Education and then to Finance.
The Senate has passed Senate Bill 483, Marshall County LSIC waiver.
Message be received. The bill will be referred to the Committee on Education.
The Senate has passed committee substitute for Senate Bill 517, clarifying PEIA plans that are exempt from regulation by Insurance Commissioner.
Message be received. The bill will be referred to the Committee on Banking and Insurance and then to Finance.
The Senate has passed committee substitute for Senate Bill 524, rewriting Board of Barbers and Cosmetologists article.
Message be received. The bill will be referred to the Committee on Government Organization.
The Senate has passed Senate Bill 558, maintaining solvency of unemployment compensation fund.
Message be received. The bill will be referred to the Committee on Finance. Resolutions.
House Concurrent Resolution 67 by Delegates Phillips, Rodegaro, and Eldridge, Valentine Brothers Memorial Bridge.
Gentleman from the 58th.
Thank you, Mr. Speaker. I ask unanimous consent that further reading of resolutions introduced be dispensed with, and that each resolution be formally introduced and referred to the appropriate committee as listed on the Chamber Automation System.
The gentleman from the 58th asks unanimous consent that further reading of resolutions introduced be dispensed with, that each resolution be considered formally introduced and referred to the appropriate committees as indicated on the Chamber Automation System. Is there objection? Chair hears none. Each resolution will be considered formally introduced and so referred. Petitions.
Delegate Miley asks unanimous consent to present a petition from the floor. Delegate Miley presents petitions from more than 4,700 citizens in support of the legislature acting immediately to fund and fix PEIA.
Without objection, the petitions will be received and referred to the Committee on Finance. Motions. Gentleman from the 58th.
Thank you, Mr. Speaker. I ask unanimous consent that for the remainder of the session, members of conference committees be permitted to vote on any question or issue before the House which they have missed as a direct result of their duties on a conference committee, provided that such members notify the clerk of the House in writing as to how they wish to vote on the day of the votes are missed, and that any such vote will not change the outcome on any question.
The gentleman from 58th asks unanimous consent that for the remainder of the session, members of the conference committees be permitted to vote on any question or issue before the House which they have missed as a direct result of their duties on conference committees, provided that such members notify the clerk of the House in writing as to how they wish to vote and on the day the votes are missed, and that such vote will not change the outcome of any question. Is there objection? Chair hears none. Bill's introduced.
House Bill 4541 by Delegates Phillips, Falk, and others, limiting the authority of municipalities to regulate the purchasing, possessing, transferring, owning, carrying, transporting, selling, and storing of knives.
Gentleman from the 58th.
Mr. Speaker, I ask unanimous consent that further reading of bills introduced be dispensed with, and each bill be considered formally introduced and referred to the appropriate committee as listed on the Chamber Automation System.
Gentleman from 58th asks unanimous consent that further reading of bills introduced be dispensed with, that each bill be considered formally introduced and referred to the appropriate committees as indicated on the Chamber Automation System. Is there objection? Chair hears none. Each bill will be considered formally introduced and so referred. Unfinished business. Bills on third reading.
Senate Bill 15, adopting learned intermediary doctrine as defense to civil action due to inadequate warnings or instructions.
Question for the House is the passage of the bill. The gentleman from the 27th, Delegate Schott, to explain the bill.
Thank you, Mr. Speaker. Senate Bill 15 codifies the learned intermediary doctrine in product liability civil actions relating to prescription drugs and medical devices. This legal doctrine provides a limited exception to the general rule that a manufacturer of a product owes a duty to the consumer to warn of foreseeable dangers in the use of the product. The learned intermediary doctrine holds that a drug manufacturer's duty to warn consumers about the dangers of its prescription drugs extends only to the prescribing physician or healthcare provider who acts as a learned intermediary between the manufacturer and the ultimate consumer and assumes responsibility for advising the individual patients of the risks associated with the drug. Stated a different way, a prescription drug manufacturer's duty to provide adequate warnings is owed to the prescribing physician and not to the patients. The rationale behind this limited exception to the legal doctrine is that the prescribing physician is in a superior position to impart the warning and can provide an independent medical decision as to whether use of the drug is appropriate for treatment of a particular patient. Hence, the doctrine is premised upon preservation of the physician-patient relationship and prevents imposing a duty upon a manufacturer to warn different than what a physician counsels or determines appropriate for his or her patient. Dating back to 1948, the learned intermediary doctrine has been widely accepted and has been adopted by court decisions or statute in all but 2 states, Arizona and West Virginia. In 2007, the West Virginia Supreme Court formally declined to adopt the doctrine in West Virginia. No other state or jurisdiction has adopted the same holding as our Supreme Court. Instead, the trend has been in the opposite direction. Last month, the Arizona Supreme Court formally recognized and adopted the learned intermediary doctrine. In doing so, the Arizona Supreme Court noted the West Virginia case and rejected it, noting that it has been criticized and not adopted by any other jurisdiction since it was issued. Accordingly, as of today, West Virginia is the only state that has not adopted this learned intermediary doctrine. Senate Bill 15 corrects this and puts West Virginia in line with the rest of the country. Specifically, the bill establishes the doctrine in code and establishes a defense to a claim by a consumer for failure to properly warn. However, the bill does provide an exception to this doctrine. Specifically, it holds that a manufacturer may still be liable if it failed to provide reasonable instructions or warnings to the prescribing physician or healthcare provider, and that failure to provide those warnings was a proximate cause of the harm. I should note that West Virginia Code Section 57-723 does provide immunity to healthcare providers from patients or third parties for injuries sustained as a result of the ingestion of a prescription drug or use of a medical device, so long as it was prescribed or used in accordance with U.S. FDA instructions. That immunity protection is available unless the doctor had actual knowledge that the drug or device was inherently unsafe for its intended purpose, or that the manufacturer publicly announced changes or contraindications that the provider failed to follow. Again, this doctrine is only applicable to a cause of action against a manufacturer for a failure to properly provide instructions or warnings regarding prescription drugs and medical devices. It does not apply in other causes of action that a consumer may have against a manufacturer, including design or manufacturing defects. Mr. Speaker, I urge passage.
Are there other members desiring to speak to the passage of the bill? Gentleman from the 19th, Delegate Perdue.
Gentleman yield.
The gentleman yields.
Certainly.
Thank you, Mr. Chairman. So, direct-to-consumer advertising, wherein a particular drug has a number of disclaimers, and we see this all the time on the bottom of the screen. Would this legislation have any influence or impact on the need for pharmaceutical manufacturers to do that in the state of West Virginia or not do that in the state of West Virginia?
I think if you look at the purpose of the bill that's noted in the subsection B, which reads, "It's the intention of the legislature in enacting this section to adopt and to allow the development of a learned intermediary doctrine as a defense in cases based upon claims of inadequate warning or instruction for prescription drugs." The way I interpret that, and the way I understand it's been interpreted in other states, is that this is a fact-based determination, that this defense is available, but it can be overcome. For instance, in the situation where we all see, for instance, a number of drugs advertised on television that just proliferate in the market. In that case, it would be necessary for, I think the argument would be, it'd be necessary for the physician to have adequate information to overcome that influence in order for this doctrine to prevent its application. So I think there's going to be once we embrace this doctrine, as every other state has, there'll be a time during which there'll be some development of how it's fleshed out. In other words, the meat's put on the bones of the doctrine and how it's applied. And I think in your case, the case you mentioned, if I understood you correctly, that would certainly be a factor that would come into play.
Sir, have there been any cases relative to what we just discussed in other states? I know that the vast majority of states have this doctrine.
All states do, except us.
Has there been any litigation, again, relative to the question I just raised with regard to direct-to-consumer advertising? I understand your argument, and I think it's correct.
Well,
but I'm just wondering if there's any kind of
if you're talking about direct marketing to the consumer that bypasses the physician, obviously this doctrine would not provide a defense, because if the consumer buys directly from the manufacturer or from some website, for instance, I don't see how this doctrine would be triggered, because there's no intermediary. There's no learned intermediary in the middle of that. Now, in terms of a physician who's involved in it, then you've got the issue of the penetration of the advertising and so forth. But as far as a specific case, I'm not aware of any. Let me check with my counsel just a minute.
Sure.
Counsel indicates he's only aware of one case in New Jersey, but it's been 10 years ago, so nothing recent to answer your question.
So if I understand the purpose that you discussed earlier, the idea is to give a physician a greater ability to overcome the things that we see on TV or that we see delivered directly to consumers.
If you look at I hope I can answer your question this way. If you look at the language of the statute, there's a lot of words in there like reasonable and foreseeable and unreasonable. A lot of, I usually call those weasel words, but they're words that can be subject to a lot of different interpretation that would allow some development based on the facts of each case as to whether it's reasonable in one situation. For instance, if there's a drug that's never been advertised anywhere and a physician prescribes it, in that particular case, and the physician has the warnings, then in that particular case, this doctrine would provide some shelter for the manufacturer. On the other end of the spectrum, you could have the situation where, and I hate that the only one that comes to mind right now is Viagra, which is, I guess, a reflection on my age.
It always comes to my mind, too.
But, but you know, we see those commercials every day, and the one with the couple in the bathtubs out in the middle of nowhere, you know, those.
Yeah. Thank you. Thank you, Mr. Chairman.
Okay.
Thank you.
Further members desire to speak to the passage of the bill. If not, question for the House is the passage of the bill. Those in favor will vote aye. Those opposed will vote no. Clerk, prepare the machine. Has each member voted? If so, the clerk will close the machine and ascertain the result. On that question, 97 ayes, 3 nays, no members absent, not voting. Majority of members present having voted in the affirmative, I declare the bill passed. Clerk, please report the title.
Senate Bill 15.
Are there amendments to the title? Not title is read by the clerk will be and remain the title of the bill. Clerk, please communicate the action of the House to the Senate. Further bills on third reading.
Committee substitute for House Bill 2122, making it illegal for first responders to photograph a corpse.
Question for the House is the passage of the bill. Chair recognizes the gentleman from 27th, Delegate Schott, to explain the bill.
Thank you, Mr. Speaker. If I can stop blushing long enough to explain this bill. House Bill 2122 is the committee substitute that prohibits only first responders from, first of all, photographing, filming, videotaping, recording, or otherwise reproducing, or from disclosing any photographs, films, videotapes, records, or other reproductions of a human corpse or a person receiving emergency assistance, except for certain legitimate purposes. Basically, the committee substitute prevents first responders from taking the picture or from disclosing the picture of a human corpse or of a person receiving emergency medical assistance, except for certain legitimate purposes. Those purposes would include legitimate law enforcement, public safety, health care, insurance purposes, or legal investigation or legal proceeding involving an injured or deceased person, or pursuant to a court order. The term first responders includes law enforcement officers, firefighters, emergency medical service personnel, and other similar individuals authorized to respond to calls for emergency medical service assistance. A first responder may disclose these images if the injured person or injured person's next of kin cannot provide consent, or the deceased person's provides legal consent, or the deceased person's legal representative provides prior written consent. The committee substitute specifically addresses motor vehicle accidents and other emergency situations. A person who violates the law is guilty of a misdemeanor and subject to the following penalties. On the first offense, a $50 to $500 fine. On a second offense, 24 hours in jail and a $100 to $750 fine. And a third offense, 24 hours in jail to 6 months in jail, that range, and either between $1,000 and $5,000 fine. The bill is designated as Jonathan's Law and is named for the fiancé of a young woman from West Virginia who the gentleman was tragically killed in a car accident, and a first responder who was there, took pictures of his deceased body and circulated them around the community, which caused much grief and trauma to the young woman and her family. And hopefully, during the course of the discussion, more details will be provided by the sponsor of the bill. There is currently no law in West Virginia that would prevent this type of situation from happening again, and therefore, Mr. Speaker, I urge passage.
Are there other members desiring to speak to the passage of the bill? The gentleman from the 42nd, Delegate Ambler.
Thank you, Mr. Speaker. The origin of this bill comes back from actually two cases that took place in my district. The tragic events that took place was that responders went and took pictures of those human remains without the consent of the family, posted those on their telephone, social media, amongst their friends, passed those around, and then to the chagrin of the families saw those photos being passed around. The photos, you can imagine the shock that would have come to those families and the feel of the invasion of their privacy, much less in a time of grief to have this happening to their loved ones. The authorities brought a case. There was a trial. The judge listened and said, we have a problem here. As deplorable as this may be, the Code of West Virginia in 1931 had nothing in there that would prevent this from happening. And as a result, the defendants in the case were let loose and, without any penalties. Now, when we introduced this bill, this is to, I hope, and I would appeal to every one of you to think about what a shock it would have been to see your loved one being circulated on social media, a picture of your mother or your father, maybe your child. The grief that it would cause. Passage of this bill today will bring somewhat of a closure to both of those families. An attempt to say, hey, you cannot do this. You cannot send photographs of people just for your enjoyment. I highly encourage each and every one of you to look into your heart and find that you do not want to find yourself in a grievable situation and see pictures of your loved ones being circulated without yours. I would highly, highly encourage you to vote yes on this bill.
Are there other members desiring to speak to the passage of the bill? The gentleman from 27 wish to close? Not the question for the House is the passage of the bill. Those in favor will vote aye. Those opposed will vote no. The clerk will prepare the machine. Has each member voted? If so, the clerk will close the machine and ascertain the result. On that question, 100 ayes, 0 nays, no members absent, not voting. Majority of members present having voted in the affirmative, I declare the bill passed. Clerk, please report the title.
Committee substitute for House Bill 2122.
Are there amendments to the title?
Delegate Schott moves to amend the title.
Question for the House is the adoption of the title amendment. All those in favor will say aye. Those opposed, no. Ayes appear to have it. The ayes do have it. Declare the title amendment adopted. Clerk, please communicate the action of the House to the Senate and request concurrence therein. Bills on second reading.
Committee substitute for House Bill 3019, requiring official business and records of the state and its political subdivisions be conducted in English.
Are there amendments? Not the bill be engrossed and advanced to third reading.
Committee substitute for House Bill 4209, relating generally to health care provider taxes.
Are there amendments? Not the bill be engrossed and advanced to third reading.
Committee substitute for House Bill 4291, increasing penalties for teachers who commit sexual offenses against children.
Are there amendments?
Delegate Schott moves to amend the bill.
The gentleman from the 27th asks unanimous consent to explain the amendment in lieu of having it read. Is there objection? Chair hears none. Gentleman from the 27th.
Thank you, Mr. Speaker. The committee substitute for House Bill 4291 relates to increasing penalties for certain educational personnel who commit sexual offenses against persons with whom they hold positions of trust. This amendment before you is simply a technical amendment. It changes the word personnel throughout the bill to the singular form person, and it's consistent throughout the bill. There are numerous places where the word personnel is in the bill, and we're just simply changing it to person to make it clear that it's a singular instead of a plural. Mr. Speaker, I urge adoption of the amendment.
Are there other members desiring to speak to the adoption of the amendment? Not the question for the House is the adoption of the amendment. All those in favor will say aye. Aye. Those opposed, no. Ayes appear to have it. The ayes do have it. Declare the amendment adopted. Are there further amendments? Not the bill be engrossed and advanced to third reading. Further bills.
Committee substitute for House Bill 4323, relating to the reporting of emergency incidents by well operators and pipeline operators.
Are there amendments?
Delegate Ireland moves to amend the bill.
The gentleman from the 7th asks unanimous consent to explain the amendment in lieu of having read. Is there objection? Chair hears none. Gentleman from the 7th.
Thank you, Mr. Speaker. Ladies and gentlemen, the amendment to House Bill 4323 is basically a committee amendment that exempts from pipeline facilities any pipeline that is 4-inch or less in diameter inside that services a farm or residence. And I would urge adoption.
Gentleman from the 40th, Delegate Armstead.
Okay. Thank you, Mr. Speaker. Mr. Speaker, I intended to make a request pursuant to Rule 49 tomorrow on passage of this bill, but would go ahead and make that request today so that it could be made for any amendments and actual final passage of the bill. As I explained yesterday in terms of a similar bill, my employer is a pipeline company, interstate pipeline, that could be affected by this bill, and so therefore I would ask if I should be excused from voting pursuant to Rule 49 on both the amendment and on passage and any related votes on this bill.
Thank you. To the gentleman, it would be the ruling of the chair that in voting on this bill you would be a member of the class and would not gain or lose particularly from the passage or rejection of this bill. Therefore, I would direct the gentleman should vote.
As we've seen before, Delegate Tim Armstead has to leave the Speaker's podium and go down to the floor in order to ask for this. He
Not
can't do it from the
the adoption of the amendment. All those in favor will say aye. Those opposed, no. The ayes appear to have it. The ayes do have it. Declare the amendment adopted. Are there further amendments? Not the bill be engrossed and advanced to third reading.
House Bill 4347, providing pregnant women priority to substance abuse treatment.
Are there amendments? Not the bill be engrossed and advanced to third reading.
House Bill 4378, relating to access to and receipt of certain information regarding a protected person by certain relatives of the protected person.
Are there amendments?
Committee on Judiciary moves to amend the bill.
The gentleman from the 27th delegate Schott asks unanimous consent to explain the amendment in lieu of having it read. Is there objection? Chair is none. Gentleman from the 27th.
Thank you, Mr. Speaker. The purpose of House Bill 4378 was to provide access to and receipt of certain information regarding protected persons by certain relatives of the protected person. In the bill, there was reference to the protected person's health being in significant decline, and it was noted during the committee process that most people who are in the status of protected person have long-term health decline. So this amendment simply adds the word recent into that description so that the health has to be in recent significant decline. It is simply modifying and restricting the significant decline to a recent period of time necessary to achieve the purpose of the bill, and I recommend its adoption.
Are there other members desiring to speak to the adoption of the amendment? Not the question for the House is the adoption of the amendment. All those in favor will say aye. Aye. Those opposed, no. Ayes appear to have it. The ayes do have it. It occurred. The amendment adopted. Are there further amendments? If not, the bill will be engrossed and advanced to third reading.
House Bill 4417, increasing wages protected from garnishment.
Are there amendments? If not, the bill will be engrossed and advanced to third reading. Bills on first reading.
Committee substitute for House Bill 2904, requiring the clerk of a county commission to maintain a county ordinance book.
Bill be advanced.
Committee substitute for House Bill 4174, exempting activity at indoor shooting ranges from the prohibition of shooting or discharging a firearm within 500 feet of any church or dwelling house.
Bill be advanced.
Committee substitute for House Bill 4467, including financial aid planning and completion of the free application for federal student aid in secondary school instruction and personal finance.
Bill be advanced. Leaves of absence. Remarks by members of the House. Gentleman from the 48th, Delegate Miley.
Thank you, Mr. Speaker. I just want to take a few minutes to note that today's the 35th day of the legislative session, and as of yet, I'm not aware of any plan to fix and restore the funding to the PEIA cuts in benefits. I appreciate that there are numerous hearings by agencies regarding their budgets, but to work on a fix for PEIA as well as conduct those hearings aren't necessarily and don't need to be mutually exclusive. Both can be done while we are working here during the 60 days. I have heard that there is going to be a bipartisan plan and bipartisan support for such plan. However, I have not been made aware of any such plan to encourage that bipartisan support. And at the beginning of the floor session, I also conferred with the Minority Chair of Finance, who's made himself available to provide bipartisan input and support for a plan to fix the PEIA shortfall. So once again, Mr. Speaker and Mr. Chairman of Finance, I urge that work begin in haste on funding and completely restoring the PEIA shortfall that affects so many of our citizens in this state. Earlier today, I presented over 4,700 petitions by people who feel that the shortfall in PEIA will have a disastrous effect on their family finances and ask for the immediate action to be taken. To that end, today you will note on the bills introduced is House Bill 4564, which provides a complete funding and restoration of the PEIA benefit cuts. I believe all of the sponsors are from the minority party, but if it was taken up and adopted by the majority party, that would indeed be a bipartisan plan and support to restore the funding. So with that, Mr. Speaker, I thank you for the opportunity to speak on such an important issue of restoring the PEIA funding cuts.
John from the 55th, Delegate Spinall.
Thank you, Mr. Speaker. And briefly, I discussed with the minority leader. Don't tell us what you value. Look at the bills that this House has passed up to this point in session, and that will show you what we value. Up to this point, we have repealed the prevailing wage. We've passed right to work. This House has passed constitutional carry. We've passed a bill that now homeschooling teachers don't even require a GED or a high school diploma to teach. We have passed a freedom of religion bill, and today, I understand the importance of it, but we have passed a bill that you cannot photograph corpses in the state of West Virginia. We are on the 35th day of a 60-day legislative session, nearly 60% of the way through. We have yet to hear a plan for PEIA. I stood here 3 weeks ago trying to make an amendment in this body on a supplemental to have fund that issue. We got $120 million. We got approximately 25 days left to go before the end of session. And we have yet to see a plan implemented by the majority party. The minority parties implemented a plan. The governor's implemented a plan. And here we are. So don't tell us what you value. All you got to look at the bills that have come out of this House and see the PEIA is being neglected. And it's going to be very unfortunate when we get to the last day and nothing's been done on PEIA. Thank you, Mr. Speaker.
John from the 16th, Delegate Morgan.
Thank you, Mr. Speaker. I didn't want you all to think that I wasn't going to have something to say today. I am a do-it-yourselfer. I'm not a very good one, but nonetheless, I have a toolbox. And in my toolbox, I try to have tools that I use to complete the work I'm doing. In the last couple of sessions, West Virginia has added lots of things to their toolbox. Right to work, prevailing wage, they've taken the sales tax off food. We've cut corporate net income tax. We've done away with the franchise tax. We've revamped workers' compensation. We took care of medical malpractice. We had a lot of legal reforms. We've had a few cuts in personal income taxes, and now we've had crowdfunding, which I understand is another tool in our toolbox. I'm not sure who's using the tools in the toolbox, but it doesn't seem to me like we're getting much done with those tools in the toolbox, and we must be going around a big box store to look for more of them, because we're considering taking up something to do with the motto, "In God We Trust." Certainly we've had concealed carry, we've had religious freedom. We're thinking about redoing education again and again and again and again. We're thinking about regulation on women's rights and equal pay. We're talking about removing taxes on coal, but not necessarily knowing how we're going to replace that. While looking through things, I found that there is no consensus, according to the University of Michigan whatsoever, that cutting taxes is a good strategy to boost state economic growth and create taxes. According to our neighbors at the University of Kentucky, they say that that Kentucky has not done well, and the biggest factor in Kentucky's poor economic performance was its stock of knowledge, particularly its low-level education among the workers, and that corporations looking for places to settle found that the availability of skilled workers was second only to highway accessibility. So what have we not done? We haven't done anything about roads. You heard from two of my colleagues, we haven't done anything about PEIA. We haven't done anything about employee pay, teachers, state workers, correction workers, law enforcement, whatever. We have not done anything to educate our workforce. We've cut budgets in secondary and higher education. We haven't talked about sin taxes, tobacco taxes, or other taxes, which somebody has talked about on various occasions. We have annotated property taxes that we haven't done anything about, and we're certainly hearing about the money that goes into racing subsidies. I think the few words that I would leave in closing is, we can't cut our way to prosperity. What in the hell are we going to do? Thank you.
Jump from the 60th, Delegate Faircloth.
Thank you, Mr. Speaker. Well, I'm sure if this bill, the repeal of Common Core, would come out in front of us, it would have a lot of overwhelming support. And I'm sure that if this piece of legislation found its way to the floor, one way or the other, it would get a vote. Thank you.
Gentleman from 63rd, Delegate Folk.
I'm going to talk about Common Core here in a minute, but first I want to address the gentleman from the 48th bill. We cannot tax our way out of pretty much anything. We don't live in a vacuum in West Virginia. For somebody to say, let's just raise the cigarette tax to, I think in this case, $1, they think that there aren't roads and bridges across rivers. The Ohio River is pretty long, borders Ohio, and up in the northern panhandle, I believe, if the gentleman from the first has told me accurate information, which he's a pretty honest man, so I'd say he's probably accurate. People actually come across the border right now to buy cigarettes in West Virginia. So we're getting tax revenue from Ohio that if we had a similar tax rate, guess what? They might just stay in Ohio and buy them there. So we'll have a loss of revenue. And over in our area, in Berkeley County, in Jefferson County also, just to the south of us is one of the lowest tax cigarette states in the country, Virginia. In addition, they're also 35, 40 cents a gallon cheaper in gas. If you think that we can tax our way to fix PEIA, I'll find some land to sell you in oceanfront property in West Virginia, because it just won't work. Now, I will agree with the gentleman from the 48th in that we need to take action sooner rather than later. And I say this because we've had a paradigm ever since I've been down here that we pass a budget after the session and let the governor veto whatever he wants. The reality is, if we put this in the budget bill, and solely in the budget bill as a way of funding it, I'm not, depending on how we fund it, he might line item it. And I think this body, both sides of the aisle, wants to fix PEIA. So I truly believe a separate bill to fix PEIA in the next year is the proper mechanism, and it needs to be done soon enough. So if need be, we can take it up as a body to override any potential veto. Because there have been things ever since I've been down here that both sides of the aisle agree with that go over to the governor and get line itemed. And I know nobody in this chamber wants to see that happen with PEIA. So really, we need to change our paradigm. We need to do something proactive earlier rather than later, so we have time to actually consider, if there isn't a veto of that particular legislation, that we take it up as a body and fix it, even if we have to compromise with the governor in some sort of way. Now, last week or a couple weeks ago, I spoke about Common Core, and I spoke about it specifically with the math. I'm going to read a little bit of a book here. It's called The Cult of Common Core by a teacher from Arizona named Brad McQueen. And he was a member of a group of educators from Arizona that were sent to the PARC, which is the sister organization to the Smarter Balanced, that created one of the two major tests. So he was one of the top educators in Arizona, and he wasn't a teacher that became a teacher right out of college. Went to college to be a teacher. He was a second career person that went back and became a teacher later in life. So he had a lot of questions at the beginning when he met with these PARC people in Chicago. What were the standards? Who wrote them? Who approved them? What would the test be like? Who was running the show? I just wanted some clarity, he says. And finally, he realized, he says, my eye-rolling Common Core handlers were not interested in my curiosity or all my enthusiastic questions. I was told that I was in Chicago to get feedback on the Common Core test and that I should check out the Common Core website to answer any questions that I had. Until then, do not critique the test. Basically, he said I had not drunk the Common Core Kool-Aid yet. Besides, I didn't speak in acronyms or talking points like the other high-level inductees of the Cult of Common Core. Now, he further goes on. Basically, it was about talking about the writing portion of the test. And he was told, in an answer to questions I had about a student writing sample, my Common Core handler finally blurted out, "We don't ever care what the kids' opinions are. If they write what they think or put forth their opinion, then they will fail the test." This guy says, Mr. McQueen says, "I've always taught my students to think for themselves. They are to study multiple views on a given topic, then take their own position and support it with evidence." But the Common Core people, this is in Chicago, at an actual meeting, said, "That is the old way of writing. We want students to repeat the opinions of experts, so-called experts, that we expose them to on the test. This is the new way of writing with Common Core." So you see, you hear all these talking points from our superintendent and everybody else that's pro-Common Core that we're supposed to be developing critical thinking. Well, I just gave you an example where they don't want you to critically think at all. They want you to regurgitate. They want you to be little soldiers to do exactly what they want, not anything else. They don't want you to think for yourselves. They don't want you to question. Now I'm going to jump to a little bit of information that some of you might not be aware of. From a chapter called Pimp Daddy Bill Gates. This book was written in 2014. At that point, Bill Gates Foundation, the Gates Foundation, $2.3 billion in support of Common Core. Now let's look at specifically where some of that money went, because then you'll start to get the picture. In 2013, these are numbers from 2013 only, the National Conference of State Legislators, $557,000. The NEA Foundation, a little over $500,000. The National Governors Association, $750,000. The NEA Foundation, another part of the NEA Foundation, almost $3.9 million. The Council of Chief State School Officers, $4 million. These are documented from the Gates Foundation website. So you have to ask yourself, who's pushing this? Now, more interestingly, you look at the standards work groups, the national standards work groups that were appointed by the National Governors Association. Let's look at some of the people on that math standards work group. There were 15 people, several from ACT, one from the College Board, several from Achieve Incorporated, which is the nonprofit of one of the three groups that developed Common Core. But you know, interesting enough, I don't see one teacher on that list. And actually, in the case of math, I don't even see one math professor on that list. And now you look at the English Language Arts Work Group. Again, members from different nonprofits, Achieve Partners, ACT. Oh, I found one professor from UC Davis, Sandy Murphy. There's your token professor in the work groups that developed English standards. Now there was a validation committee later that validated the standards. There were a few professors on that validation committee. Two I know of specifically. One in ELA, a lady by the name of Sandra Stotsky, who has presented in front of this body up in Clarksburg and then I think down here once, and a guy named James Milgram. Both people that were in charge of the developing standards in their respective fields. Milgram in California, Stotsky in Massachusetts. Milgram's standards that he was involved in developing that took effect in the mid-90s showed success, more importantly, showed success on low income and minorities. Very good success. And both those individuals that were highly respected in their fields would not support Common Core. In closing, I can only say that I'm amazed and have some of the same sentiments from the gentleman from the 48th that there are certain issues in this state. If you talk to any grandparent or any parent that has kids in public schools, most of them will tell you there's a problem with Common Core. And I'll tell you up front, I used to teach. My wife taught for 12, 15 years. My brother teaches. I have many friends that are teachers from my experiences as a teacher. And I even have, we took our children out of the public schools because the math was that bad. I'm actually using, believe it or not, some math books from 1928 to teach my kids math. And they're actually excellent math books. I showed one of them to my sister-in-law, who was a double major in biology and mathematics, and she loved the way they taught math. She actually hadn't seen it before. I've shown it to some secondary math teachers who hadn't seen it before. See, the math issue is not a new issue. They tried something new in math in the 90s. In the early 90s, after I graduated high school, while I was in college, they started to say, we're going to let the kids use technology. They don't need to know they don't need to know what 6 times 6 is. If they can use a calculator, it's fine. So in the middle school, it was Musselman Middle School at the time. I taught at the high school. But I was getting kids that had were allowed to use calculators in basically everything they did in middle school. I taught algebra at 9th grade. The kids didn't even know even the good students didn't know their multiplication tables. And it's amazing. The irony in that statement is that we switched back, and the one lady that I know that taught at Musselman Middle School, who I approached about that one time, because she was, as you probably well know, I was pretty vocal in the last year about mathematics problems. That teacher was the one that allowed these kids to use calculators. And she wants to go and try the new math again. Fool me once, shame on you. Fool me twice, shame on me. And I think we need to do something. Thank you.
Miscellaneous business. Gentleman from the 58th.
Mr. Speaker, subject to announcements, I'll move the House adjourn until 11 a.m. tomorrow.
Prior announcements. Gentleman from the 64th, Delegate Householder.
Thank you, Mr. Speaker. The Committee on Finance will meet tomorrow morning, beginning at 9 a.m. to consider legislation. The agenda will be posted. The committee will meet again in the afternoon, beginning at 2 p.m. to consider legislation, and that agenda is posted. Thank you.
John from 38, Delegate Lane.
Thank you, Mr. Speaker. The Committee on the Judiciary will meet tomorrow morning at 9 a.m. The agenda will be posted.
John from the 61st, Delegate Duke.
Thank you, Mr. Speaker. Your Committee on Education will hold a public hearing on House Bill 4310 relating to West Virginia University Institute of Technology tomorrow morning at 9 a.m. and here in the House chamber. In addition, Mr. Speaker, your Committee on Education, full committee, will meet at 2 p.m. tomorrow. The agenda is posted, and immediately following that meeting, your subcommittee looking at public school funding will meet in the committee room, and the agenda for that meeting is also posted. Thank you.
Lady from the 31st, Delegate Audubon.
Thank you, Mr. Speaker. Your Committee on Government Organization will meet at 9 a.m. Wednesday, February 17th in the Government Organization Committee Room, 215 East. The agenda will be posted.
Lady from the 49th, Delegate Summers.
Thank you, Mr. Speaker. Your Committee on Health and Human Resources will meet today at 2 o'clock in room 215E. The agenda is posted. The Republican members will caucus at 1:30 in the chairman's office.
Jump from the 53rd, Doggett Smith.
Thank you, Mr. Speaker. Your Committee on Energy will not meet today. I repeat, your Committee on Energy will not meet today.
Jump from the 35th, Doggett Stansbury.
Thank you, Mr. Speaker. Your Select Committee on Prevention and Treatment of Substance Abuse will meet today at 4 p.m. in the GovOrg room. We'll be taking up bills. The agenda has been posted, and the Republican members will caucus 15 minutes prior in the chairman's office.
Jump from the 33rd, Doggett Hanshaw.
Mr. Speaker, the Judiciary Subcommittee considering the Article 5 Convention bills and resolutions will meet at 8 o'clock Thursday morning, day after tomorrow, in the Judiciary Committee room. And on everyone's desk was hopefully an invitation to a presentation tomorrow morning on mineral taxation in West Virginia. A number of us have heard from constituents with concerns regarding mineral taxation issues. We'll have a professional tax attorney on hand tomorrow morning to talk about how we tax minerals in West Virginia. All are welcome.
Jump from 28th, Doggett Cooper.
Thank you, Mr. Chairman. Your Committee on Veterans Affairs and Homeland Security will meet tomorrow at 1 o'clock in the Education Committee room. The agenda will be posted. Thank you, sir.
Jump from the 12th, Doggett Westfall.
Mr. Speaker, your Committee on Banking and Insurance will meet Wednesday, January 17th at 4 o'clock p.m. Eastern Standard Time, and the Judiciary Room. We also will meet again on Thursday morning at 10 o'clock as scheduled. The agenda will be posted for both meetings, but again, this is unusually Wednesday at 4 o'clock, Judiciary Room. Thank you, Mr. Speaker.
Jump from the 14th, Doggett Butler.
Thank you, Mr. Speaker. Your Committee on Political Subdivisions will meet today. We were scheduled at 1. I suppose we'll go as soon as the caucus is over. And then also, if we don't get our agenda done, we will meet at 5 this evening in the House Education Committee room. The agenda is posted.
Jump from the 8th, Doggett Anderson.
Thank you, Mr. Speaker. The Republicans will caucus at 1 p.m. sharp in the chamber.
Jump from the 1st, Doggett McGinn.
Thank you, Mr. Speaker. Permission to return to the previous order of business for remarks by members. I had my light on, I thought, and this book I had resting on my desk, I think, turned it off.
Okay.
And I had some comments to make.
Without
Would
objection.
that be acceptable?
Is there objection? Chair is now. Gentlemen may proceed.
Thank you, Mr. Speaker. I wanted to draw the members' attention to a certain situation. There's been a lot of talk in this chamber lately about the First Amendment, especially during the heated debates last week, citing the First Amendment over and over. But what is the First Amendment truly mean and truly stand for? The First Amendment was primarily designed to restrict and prevent the government from initiating aggression towards the citizenry for speaking their free thoughts and minds, especially when it comes to speaking out against the government. And of course, no greater example of this comes from the early days of the Republic, when the Federalists passed into law what was known as the Alien and Sedition Acts, effectively outlawing any citizen from speaking or criticizing certain government officials back in those early days. And ironically, the Alien and Sedition Acts were passed just a few years after the First Amendment was ratified by the several states. And of course, this prompted Jefferson and Madison to pen the famous Kentucky and Virginia resolutions. But so how do these lessons, though, from history relate to today in our modern times? And I want to tell you a story, a very recent story, regarding one of my own constituents back home in Hancock County, which took place this past year. So a glaring example of this deviation from constitutional law and the First Amendment within my district had to do with the recent case of a man from New Cumberland. His name is Mr. David Jones, retired Air Force veteran of 20 years, with not even a parking ticket to this man's name. Honorable discharge. This man served in the Air Force, did one tour in Iraq. When he retired, he moved back home to New Cumberland. In late June of this past year, Mr. Jones was arrested in his home and placed in jail. His crime, under an obscure West Virginia law, Mr. Jones was charged with 2 felonies for 2 Facebook posts he made on his personal Facebook page. Statements were written on his Facebook page, which he was charged with, over a year prior to his arrest. Statements that alleged to have been retaliation against various government officials. Notwithstanding the complete absence of harm ever coming from anything this man ever typed on the internet, Mr. Jones had his bail set at $200,000. Now, I know certain people that are charged with first-degree murder that have their bonds set much lower. So, unable to pay this steep sum of money, this veteran sat in prison for nearly 30 days until he was finally released after his bond was suddenly dropped to 0. The charges against this American veteran, however, still remain. But to understand this case and why it matters, we should examine a little bit of background information. Though I never knew this gentleman, Mr. David Jones, I knew of him. In fact, I venture to guess most people involved in politics in my area know about him as well. That's because he's a very opinionated person. For several years now, the last 5 or 6 years, Mr. Jones has used his personal Facebook page to post statements that are very critical of government officials in our community, in my district. And in a sense, he's more or less a political activist, a political protester. And he tries to draw attention to issues he cares about by using provocative, sometimes hostile language. And this gentleman has been doing this for 6 or 7 years, and everyone knows that, he's sort of less a political protester in our area. He denounces government corruption, and he has a few issues like that. Now, the language he uses is very malicious and vitriolic, okay? And sometimes the language he's chosen has been downright hateful. I came to know this because he has blasted me several times over the last couple years on the internet, saying very difficult and very hateful things against me. Needless to say, we're not friends, okay? Actually, last Halloween, he put a giant billboard in his front yard that said something like, "Pat McGeehan is a complete jerk," but it was profanity, so I won't repeat what the sign actually said. That's his right, under the First Amendment. He could post that stuff on his property and say whatever he wants on the internet. That's fine. I don't condone the language, but I believe there's far better ways to get one's point across when it comes to debating government policies. However, one tenet of the rule of law is that justice must be blind. And for it to remain so, we should remember government officials cannot think and act with emotion simply because a person might be disliked or hated in the community. We must always use reason and not emotion when we're dealing with certain matters like this. Furthermore, there's a vast difference between language and action. One is protected by the First Amendment to the Constitution, guaranteeing the right of free speech. Just 7 months ago, ironically, 1 month before this gentleman was arrested at his home for Facebook posts, which were not threatening at all, there was a near unanimous decision with the Supreme Court, which made a ruling to throw out criminal charges against a Pennsylvania man who had actually written and posted threatening statements on Facebook and the internet, not only just using like hostile language. This man from Pennsylvania that went all the way to the Supreme Court had actually made direct threats against his ex-wife, along with other private citizens. But the Supreme Court ruled the man had committed no crime and that what he wrote on the internet is indeed protected free speech, quite simply because of the First Amendment. Now, is it moral to use such language? In my opinion, clearly not, but sometimes we can get caught up only looking at the trees and we forget to see the forest. Nearly every official in government, including everyone in this chamber, must take the oath of office when they first assume their duties to support and defend the Constitution of the United States, so help me God. That includes the entire Bill of Rights. And this should be a sacred and precious thing to always cherish. For defending the Bill of Rights is our first and foremost obligation in office. I'm reminded by those famous words from John Adams to remain a country of laws and not of men. We must always try to remember that when we protect those in our society that may be scorned, disliked, or hated, but have caused no physical harm, we also strengthen and protect the very fabric of our American way of life. Now, I actually received a lot of criticism because after this took place and this man was arrested and thrown in prison, after I got all the details from law enforcement on the case and realized it truly was an arrest made simply because this guy had been critical of different government officials, under this clause in our state law that says you cannot retaliate against public officials in their official performance of their duty. Now it's being misconstrued by some prosecutors as saying, well, we can go after guys that are critical of government officials because that somehow applies to retaliating against government officials, because if we criticize someone on their votes, then all of a sudden that's retaliating against them in their official performance of their duty. So I did receive a lot of criticism at the time because I agreed to a lot of news interviews saying, hey, look, we don't have the First Amendment just to talk about the weather. But before I chose to actually go out and defend this man, which I just thought I was defending the rule of law, really is how I took it. Ironically, I just finished teaching my high school Sunday school class the Sunday before about, the Christ said, not only love your neighbor, but also love your enemies. And so even though this gentleman's been very critical of me over the past 3 or 4 years, that's what sort of made my decision, of course, along with my obligation to uphold the oath of office. So, I'll simply quote the Stoic philosopher Epictetus that came to mind, actually, when I was making my decision to stand up for the rule of law up in my district. And Epictetus wrote, according to Arian, if you want to improve and pursue virtue, be content to be thought foolish and do not bother what others may think of you. So I'll be introducing a bill to repeal this obscure statute, this statute that says no one can retaliate against government officials if they're acting in their public performance of their duties, which really I don't believe that anyone in elected office needs some sort of extra legal protection But since it's also now being misinterpreted by not only prosecutors up in my district, prosecutors around the state as being able to suppress internet free speech, I think this is something important that we really need to address now. So sorry to take a little bit of your time here. I know everybody's got some other things to attend to, but it's very important to me, and it's very important to uphold our oaths of office. So thank you very much.
The gentleman from the 50th, Delegate Caputo.
Thank you, Mr. Speaker. First, an announcement: the Democrats will caucus at 1 o'clock in the Gov Org Committee Room. And also, Mr. Speaker, I'd like to ask unanimous consent that the remarks from the gentleman from the 55th, the Minority Leader, gentleman from the 48th, and Delegate Morgan, the gentleman from the 16th, be printed in the appendix of the journal.
Is there objection? If not, so ordered. Delegate from the 10th, Delegate Azinger.
Thank you, Mr. Speaker. I just request that the remarks of the delegate from the first be printed in the journal, please, the back of the journal.
Okay. Is there objection?
What I said.
Hearing none. Is that to the gentleman, the appendix of the journal?
Yes, sir.
To the appendix journal. Is there objection? Hearing none, so ordered. Lady from the 43rd, Delegate Campbell.
Thank you, Mr. Speaker Pro Tem. I have two announcements. Your Democratic members of the Health Committee will caucus at 1:30 in room 252. And then this evening, the West Virginia Nurses Association will be having a reception for all members of the House and the Senate at 6 p.m. at the Marriott from 6 to 8, West Virginia Nurses Association. Thank you.
Ladies and gentlemen, the question before the House is a motion from the gentleman from the 58th that we adjourn until 11 a.m. tomorrow. All those in favor say aye. Aye. No? So ordered. Adjourn until 11 a.m. tomorrow.
And that concludes today's House floor session, live from the House chamber at the State Capitol in Charleston. Before we leave the House of Delegates, a reminder: the House Education Committee is holding a public hearing tomorrow morning at 9 in the House chamber. At issue is House Bill 4310 to help ensure the continuing viability and vitality of West Virginia University Institute of Technology by providing flexibility to West Virginia University and WVU Tech to relocate from Montgomery to Beckley and to facilitate collaboration between four-year institutions serving southern West Virginia. That's a public hearing held tomorrow morning at 9 in the House chamber, and you will see it live here on the West Virginia channel. We will be taking you to the Senate floor session recorded from earlier today, a review of some of the highlights of today's Senate floor session. Among the bills up for passage and debate, Senate Bill 272, allowing investigators from the Attorney General's office to carry concealed weapons. Senate Bill 298, allowing restaurants, private clubs, and wineries sell alcoholic beverages beginning at 10 a.m. on Sundays. Senate Bill 516, relating to registration for selective service, to require automatic enrollment of certain persons required to register for selective service by the Division of Motor Vehicles. Also up on third reading in the Senate today, 8 bills repealing certain obsolete legislative rules by various state agencies. Among the bills on second reading in the Senate, the amendment stage, Senate Bill 10, creating the Unborn Child Protection from Dismemberment Abortion Act. Senate Bill 16, providing a tax credit for providing broadband service to unserved areas. Senate Bill 105, creating the Tim Tebow Act, allowing non-public school students participate in SSAC member school athletics. Those are some of the bills you'll hear about on the Senate floor session today. As we roll this, as we see the Senate beginning its session, there is a problem with the microphones on the Senate floor, but they will be turned on in just a few moments. Please stand by.
privilege of standing in this great historic chamber. But I'm honored to come into the throne room of heaven where I can lift up all of these senators in this place today. On their behalf, I ask, God, that you would bless them and grace them in their service and in the work that they do for our great state. I pray, Lord, that you would give them wisdom as they make great decisions, that you would give them clear discernment as they decide, and give them the strength to do what's right, even when it's not easy. Thank you, Lord, again for this esteemed body, and may you bless them in the process that they're in today. Bless, God, I pray continually, the great state of West Virginia, for it's in the name of your Son, my Savior Jesus, I pray. Amen.
Thank you, Pastor. The senator from Logan.
Would the ladies and gentlemen in the galleries rise and join me and my colleagues in the Pledge of Allegiance to our great country. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, liberty and justice for all.
Reading of the Journal.
West Virginia Legislature, Senate Journal, February 15th, 2016. The Senate met at
Junior
11
Senator
a.m.
from the 17th requests unanimous consent that further reading of the Journal be dispensed with, the Journal be approved. Is there objection? Chair hears none. Further reading of the Journal is dispensed with. Journal is approved. Introduction of guests. On behalf of the Senate, it is my pleasure to welcome our honorary pages for the day. Please stand and be recognized as your name is called. As guests of the Junior Senator from the 17th, Caden McCoy, Gabriel Rudge, Alea Lazar, Ashley Burford, Allie Moffitt, and Mark Steele. As guests of the Senator from Cabell, Mia Ashworth, Thomas Ashworth, and Maxwell Withers. And as guests for the Junior Senator from the 6th and myself, Delaney Quessenberry and Atticus Bogus. Please give our pages a round of applause. Senator from Jackson.
Thank you, Mr. President. It is my pleasure and yours to introduce our doctor for the day, Dr. Carolyn Curtis of Huntington, West Virginia. She's in the rear of her chamber. If she would stand, the Senate make her welcome.
Further introductions. The Senator from Marshall.
Thank you, Mr. President. It's your pleasure and mine to have visiting in the gallery today various members of the West Virginia Association of Alcoholism and Drug Abuse Counselors. And I would remind us all that they are people that many have been in recovery themselves, are helping members of our families and communities and in recovery, and that they treat those that are reaching out for help. And today I want to thank them on behalf of the Senate for all the work they do for our people, our voters, and our communities. Please stand and be welcome to the Senate.
Further introductions. The Junior Senator from the 8th.
Thank you, Mr. President. We're glad today to have the brother of Pastor Tom, Doug Price, in I think the rear gallery. Doug, if you'll stand up, let the Senate recognize you.
The Junior Senator from the 17th.
Thank you, Mr. President. With the honor of mine and the Senior Senator from the 17th, we have the chaperones to some of our pages today. The mother of Caden McCoy, Heather McCoy, if you wouldn't mind standing, as well as the parents of Ashley Burford, Gill, and Christy Lambert. Allie Moffitt, mother Tony Moffitt. Mark Steele, mother Shannon Steele. If you wouldn't mind standing, the Senate give you a warm welcome.
Further introductions. The Senator from Cabell.
Thank you, Mr. President. On behalf of the Senior Senator from the 5th, it is my pleasure to welcome the grandmother of two of our pages. That is Maya Ashworth and Thomas Ashworth. She's in the South Gallery. Would the Senate please make Tammy Varney feel welcome?
Further introductions. Communications from the House.
The Clerk of the House announced that the House has amended the bill and title as it relates to engrossed Senate Bill 123, Treatment for Sexually Transmitted Diseases.
Message to be received, the Senator from Jackson.
Thank you, Mr. President. I move the Senate concur in House amendments to engross Senate Bill number 123. The amendments made by the House of Delegates were not substantive. They were technical only in nature.
Senator from Jackson moves that the Senate concur in the House amendments to engross Senate Bill 123. All those in favor will say aye. Those opposed, no. The ayes have it. I declare the motion adopted. Question now is on passage of the bill as amended. All those in favor will vote yea. Those opposed will vote nay. The clerk will prepare the machine. Has every member voted? If so, the clerk close the machine, ascertain the results. On this question, 34 yeas, 0 nays, 0 absent, not voting. More than a majority of those elected and elected having voted in the affirmative, declare the bill passed. Clerk will communicate the action of the Senate to the House. Clerk will read the next House message.
The House passed engrossed committee substitute for House Bill 2615, the West Virginia Small Business Capital Act.
Message to be received, bill be referred to the Committee on Finance.
Engrossed committee substitute for House Bill 4146, providing insurance cover abuse deterrent opioid analgesic drugs.
Message to be received, bill be referred to the Committee on Banking and Insurance, then the Committee on Health and Human Resources.
Engrossed committee substitute for House Bill 4188, relating to the development and implementation of a program to facilitate commercial sponsorship of rest areas.
Message to be received, bill be referred to the Committee on Transportation and Infrastructure, then the Committee on Finance.
Engrossed committee substitute for House Bill 4218, expanding the definition of underground facility and the One Call System Act.
Message to be received, bill be referred to Committee on Judiciary.
Engrossed committee substitute for House Bill 4228, relating to transportation network companies.
Message to be received, bill be referred to Committee on Judiciary.
Engrossed House Bill 4309, increasing criminal penalties for conviction of certain offenses of financial exploitation of an elderly person.
Message to be received, bill be referred to the Committee on Judiciary.
The House adopted committee substitute for House Concurrent Resolution 2, naming the U.S. Army Private William Frederick Kump Memorial Bridge.
Message to be received, the resolution be referred to the Committee on Transportation and Infrastructure.
Committee substitute for House Concurrent Resolution 14, the second Friday in July as West Virginia Collector Car Appreciation Day.
Message to be received and the resolution be referred to the Committee on Transportation and Infrastructure.
Committee substitute for House Concurrent Resolution 19, naming the H. LeBon White Memorial Bridge.
The message will be received and the resolution will be referred to the Committee on Transportation and Infrastructure. Communications from the Executive.
There are none.
Reports from standing committees.
Your Committee on Finance has had under consideration Senate Bill 54, altering how taxes collected on homeowners associations, and has amended same and reports the same back with the recommendation that it do pass as amended. Respectfully submitted, Mike Call, Chair.
Report will be received.
Your Committee on Finance has had under consideration Senate Bill 293, Neighborhood Investment Program Act, and reports back a committee substitute for same with the recommendation that the committee substitute do pass. Respectfully submitted, Mike Hall, Chair.
Report will be received.
Your Committee on Agriculture and Rural Development has had under consideration Senate Bill 434, allowing home-based micro-processed foods sold at farmers markets, and reports back a committee substitute for same with the recommendation that the committee substitute do pass. Respectfully submitted, Robert Carnes, Chair.
Report will be received.
Your Committee on Banking and Insurance has had under consideration Senate Bill 547, adjusting limits on consumer loans for which finance charges can be imposed, and reports the same back with the recommendation that it do pass, but under the original double committee reference, first be referred to the Committee on the Judiciary. Respectfully submitted, C. Edward Gaunch, Chair.
Report will be received under the bill's original double committee reference. The bill be referred to the Committee on Judiciary.
Your Committee on Finance has had under consideration engrossed House Bill 4148, updating the meaning of federal taxable income and certain other terms used in the West Virginia Corporation Net Income Tax Act, and engrossed committee substitute for House Bill 4158, making a supplementary appropriation to the Department of Commerce Workforce West Virginia Workforce Investment Act, and reports the same back with the recommendation that they each do pass. Respectfully submitted, Mike Hall, Chair.
Report will be received.
Your Committee on Banking and Insurance has had under consideration engrossed committee substitute for House Bill 4244, eliminating the need for a public hearing when no objection is filed on an application from an out-of-state chartered credit union to establish a branch in West Virginia, and engrossed committee substitute for House Bill 4245, requiring the cashier or executive officer of a banking institution to provide shareholders with the institution's most recent year-end audited financial statement, and reports the same back with the recommendation that they each do pass. Respectfully submitted, C. Edward Gaunch, Chair.
Or to be received. Reports from select committees.
There are none.
Introduction of bills. Senator from Jackson.
Thank you, Mr. President. I request unanimous consent that Senate Bill number 608 through Senate Bill 610 be considered introduced, read by their titles, and referred to the appropriate committees as shown on the chamber automation system.
Senator from Jackson requests unanimous consent that Senate Bill 608 through Senate Bill 610 be considered introduced, read by their titles, referred to the appropriate committees shown in the chamber automation system. Is there objection? Chair hears none, so ordered. Resolutions.
Senate Resolution 38 by Senators Kessler, Yost, Stallings, Laird, Unger, Prezioso, Williams, Plymel, Romano, and Facemeyer, recognizing the West Virginia Federation of Democratic Women.
The Senator from Marshall.
Thank you, Mr. President. I ask unanimous consent the resolution be taken up for immediate consideration, committee reference dispensed with, and a resolution placed upon its passage.
The Senator from Marshall requests unanimous consent that the resolution be taken up for immediate consideration, committee reference be dispensed with, the resolution be put upon its adoption. Is there objection? Chair hears none. Clerk will read the resolution.
Senate Resolution 38, recognizing the West Virginia Federation of Democratic Women.
The Senator from Marshall.
Thank you, Mr. President. I appreciate the opportunity to recognize a special group of ladies here today from the West Virginia Federation of Democratic Women. I know, I think both sides of the aisle would agree that the women in our lives are the heart and soul not only of our lives, our families, our homes, our communities, and yes, even the political process. Women, and these women, bring common sense, creative ideas, and compassion to the political discussion. They work tirelessly on issues that help all of us. They lead by example, light fire in our bellies, and show us and others the way, the right way to do things. On behalf of the Senate, our side of the aisle, I'm sure as well as your side of the aisle, we appreciate all your work you do to improve West Virginia. And today we honor and recognize you for those efforts, and I'm proud to welcome you to the State Senate and urge the passage of this resolution. Thank you, Mr. President.
Further discussion. The Senator from Jackson.
Thank you, Mr. President. On behalf of our side of the aisle, we also want to join in supporting this resolution and honor the women that invest their lives to promote causes for which they believe in and that they truly want to make a difference in our society. And we stand with the minority leader in support of this resolution.
Question for the Senate is the adoption of the resolution. All Senator from Marshall.
More time, and they might have some cards where you guys want to switch over. We can get you signed up.
Do I want to recognize the Senator from Jackson to close? The question for the Senate is the adoption of the resolution. All those in favor will say aye. All those opposed say no. The ayes have it. I declare the resolution adopted. The Senator from Jackson.
Thank you, Mr. President. I move the Senate stand in brief recess for the purpose of presenting the resolution.
Senator from Jackson moves Senate stand in brief recess for purposes of presenting the resolution. All those in favor will say aye. Those opposed say no. The ayes have it. I declare the motion adopted. The Senate will stand in brief recess to present the resolution.
You're tuned to the West Virginia Legislature on the West Virginia Channel. This is today's Senate floor session recorded earlier today. There is nothing wrong with your device or your set. The Senate will be gavelled in shortly.
Senate will come to order. Motions. Petitions.
I have a petition presented by Senators Klein, Gaunch, Carnes, and Leonhardt from the National Association for Gun Rights with 359 signatures supporting House Bill 4145.
Petitions will be referred to the Committee on Judiciary.
I have a petition presented by Senator Kessler from Christine Campbell and containing numerous signatures requesting legislature to fix and fund PEIA.
Petition will be referred to the Committee on Finance. Unfinished business.
Senate Concurrent Resolution 36, naming the U.S. Army Specialist 5 Joseph Richard Rick Schaefer Memorial Bridge.
Resolution be referred to the Committee on Transportation Infrastructure. Bills on third reading.
Engrossed Senate Bill 147, providing consumer sales and service tax and use tax exemption for certain services and tangible personal property sold for repair, remodeling, and maintenance of aircraft. Third reading of the bill.
Questions on passage of the bill. Senior Senator from the 4th.
Thank you, Mr. President. This bill exempts sales of services for repair, remodeling, and maintenance to aircraft owned and operated under a to an aircraft operated under a fractional ownership program. Most well-known company that does this, and maybe the only, is NetJets, and operated under a fractional ownership program. Personal property affixed to said aircraft and the machinery, tools, and equipment directly used therein from consumer sales and service tax. It exempts them from that. I'll be glad to answer any questions.
Questions on passage of the bill. Is there discussion? If not, the question for the Senate. Senator from Harrison.
Thank you, Mr. President. Just briefly, I want to speak in favor of this bill. It's an important economic development bill that has no fiscal impact on the state at this time. We're earning no revenues from fractional share jets. This brings our sales tax exemptions into the 21st century because fractional share jets are just another form of commercial jets, but they're authorized under a different FAA section, and that's how our exemption goes. A lot of jobs hang in the balance on this bill. We had almost 200 jobs here in north central West Virginia that moved to Kansas overnight because of the failure to have this sales tax exemption. I would ask the body to please vote in favor.
Further discussion? If not, the question for the Senate, shall the bill pass? All those in favor vote yea, those opposed vote nay. The clerk prepare the machine. Has every member voted? If so, the clerk close the machine, ascertain the results. On this question, 34 yeas, 0 nays, 0 absent not voting. More than a majority of those present and voting having voted the affirmative, I declare the bill passed. Clerk will communicate the action of the Senate to the House.
Engrossed committee substitute for Senate Bill 272, allowing investigators from Attorney General's office to carry concealed weapons. Third reading of the bill.
Questions on passage of the bill. Senator from Morgan.
Thank you, Mr. President. The committee substitute for Senate Bill 272 adds a single new section to the code. It'd be Chapter 5, Article 3, Section 6. The bill does exactly what the short title says. It authorizes investigators with the Attorney General's office who are approved by the Attorney General to do so to carry deadly weapons. I'd be happy to answer questions.
Questions on passage of the bill. Is there discussion? The Senator from Marshall.
Thank you, Mr. President. Will the Senator from Morgan yield?
Senator from Morgan yield. Senator yields.
If I recall correctly, under our current Constitution and statutory makeup, that there's no criminal jurisdiction vesting in the Attorney General's office. Am I correct on that?
Let me see if I can, the gentleman may be right, but let me see if I can confirm that with counsel on that. Counsel confirms what I thought. She believes also that your assertion is correct, that they do not generally have criminal investigative authority.
So these would be civil investigations when they're looking into like consumer fraud or violations of unfair trade practices or whatever they might be bringing in order to file some type of civil suit for an injunction and or for damages?
I believe that's correct.
And you have any idea how many folks are on their staff as investigators in this capacity?
I do not. Let me see if someone over here does. Well, I have some information that is somewhat historical because our staff counsel worked formerly in the Attorney General's office, and during her tenure there, she thinks there were 3 to 5 people that worked doing those sorts of investigations.
Well, this, I know from time to time we passed a bill earlier in the session that set up a procedure for the Attorney General to hire in-house counsel that obviously is part of their duties as counsel for the state of West Virginia's special attorney generals. I'm assuming that part of their duties would concern investigating the background of the case and doing investigatory work in order to process the case. Does this bill extend those conceal carry
I would not think
to all the special attorney generals that we may have representing the state?
I would not think so. It speaks in terms of designating investigators in his or her employ, and it speaks of designated investigators. So I think that would not include deputies attorney general.
And I know we've historically extended these to folks that have law enforcement duties as part of their duties performing for governmental entities. And I'm assuming as well with this concealed carry bill that's maybe moving through the Senate now, that if that passes, would we need this at all, since anybody's going to be able to carry, whether or not they're a branch of the concealed, whether they're part of a governmental entity or not?
Well, I think that when a person is in the employ of a constitutional officer, an agency of the state government, it is still within the power of the employer to say when or not, and by law, by extension, legislative act, whether or not his or her employee, during the course of his or her official duties, should carry a firearm.
I understand. Thank you.
Thank you,
Chairman.
Is there further discussion?
President, I am concerned about the bill because, as indicated, normally we extend these type of protections to individuals who are working in a law enforcement capacity in criminal investigations, and this is the first time that I'm aware of that we've actually extended this type of protection to any branch of government for folks that are involved only in civil rather than criminal investigations. That's a concern that I do have, and for that reason I will be voting no.
Is there further discussion? If not, the question before the Senate, shall the bill pass? All those in favor will vote yea. Those opposed will vote nay. The clerk will prepare the machine. Has every member voted? If so, the clerk close the machine. Ascertain the results on this question. 29 yeas, 5 nays, 0 absent, not voting. More than a majority of those present and voting having voted in the affirmative, I declare the bill passed. Clerk will communicate the action of the Senate to the House.
Engrossed committee substitute for Senate Bill 298, allowing restaurants, private clubs, and wineries sell alcoholic beverages on Sundays. Third reading of the bill.
Questions on passage of the bill? The junior senator from the 17th.
Thank you, Mr. President. This bill is a version that's been passed around through the Senate, I think, in past and previous years. There are several versions this year. We took those together and tried to pull out the good pieces for all of them. Essentially, Senate Bill 298, the committee substitute, says that the purpose will be to allow restaurants, private clubs, distilleries, mini distilleries, and wineries to sell alcohol at 10 o'clock a.m. on Sundays. The bill does amend several sections of code to allow this to take place. It does not, however, allow the sale of off-premises on Sundays of liquor bottles, etc. So this will only be for wineries that are doing wine tastings or microbreweries, etc.,
that they can open up, and this really puts us in line with all of our surrounding states also. And restaurants, yes. Reserve the right for close if needed.
Questions on passage of the bill? Is there discussion? The senior senator from the 8th.
Thank you, Mr. President. I'll just be brief in my discussion. I rise in support of the bill. I want to let everyone know that we had discussion with Snowshoe about the potential economic development from passing this piece of legislation, and they came out with a report showing that they, at their resort, would see an increase of economic activity by $500,000 a year. So this seems like a small thing, but it really is something that can bring economic activity to our state, help our tourism industry, and keep people in West Virginia to come visit and enjoy their experience. Thank you, Mr. President.
Is there further discussion? If not, the question for the Senate, shall the bill pass? All those in favor vote yea. Those opposed will vote nay. The clerk will prepare the machine. Has every member voted? If so, the clerk close the machine. Ascertain the results on this question. 34 yeas, 0 nays, 0 absent, not voting. More than a majority of those present and voting having voted in the affirmative, I declare the bill passed. The clerk will communicate the action of the Senate to the House.
Engrossed Senate Bill 423, providing for disposition of unclaimed and unredeemed savings bond. Third reading of the bill.
Questions on passage of the bill? Senior Senator from the 4th.
Thank you, Mr. President. This bill, in the unclaimed property area, currently unclaimed abandoned savings bonds are actually returned to the U.S. Treasury. The state of Kansas successfully obtained, they passed a law similar to this that permits, or that basically says those abandoned properties, after the proper amount of time that they're unclaimed, would actually come to our unclaimed property account. So that's essentially the simple explanation of this, and I would urge its passage and would try to answer any questions if anybody has one.
Questions on passage of the bill? Is there discussion? Senator from Logan.
Yield.
Will the senior senator yield?
Which agency would be taking care of the procedure of the bonds? Would it be the Treasurer's Office, or?
Yes, it would go to our unclaimed. The person who testified was the lady that Ms. Atkinson Carolyn, who runs our unclaimed property, and she stated during the finance meeting that if we were successful with this, that it would at least bring to our state $3 or $4 million of these types of bonds that are apparently discovered in safety deposit boxes or wherever they've been unclaimed. Yeah, they would be part of our unclaimed property. That's where they would go.
So probably this type nature of unclaimed property is a little bit harder to distribute than the previous efforts they do now. This cleans it up a little bit better, makes it better to get it back to the people that rightful ownership.
Oh yeah. This does nothing in terms of trying to find the owners. Okay. It just simply says when you've come to the end of that road, that currently, the way I understand as this was brought to me by a citizen who brought this to me, that currently the bonds, once they're considered unclaimed, they would go to the U.S. Treasury rather than to our unclaimed property. But this particular enactment would provide that those bonds would come to our unclaimed property, since they're West Virginian owned or found in West Virginia banks or whatever. So yes, it would just be like abandoned bank accounts or whatever. They would go to our unclaimed property.
So prior to people trying to determine who the owners are, the state would receive the interest level on that once the bonds were sitting there? That would be a revenue increase?
Yeah, that's right, because that was part of the discussion, that the actual maturity value is not necessarily listed. That's discovered once you turn in the bond and you find out what it's actually worth as opposed to what its face value is. Okay. Does that make so? Yeah, it actually appreciates.
Okay, thank you, sir.
Yeah.
Is there further discussion? If not, the question for the Senate, shall the bill pass? All those in favor vote yea. Those opposed vote nay. The clerk will prepare the machine. Has every member voted? If so, the clerk close the machine. Ascertain the results on this question. 34 yeas, 0 nays, 0 absent, not voting. More than a majority of those present and voting having voted the affirmative, I declare the bill passed. Clerk will communicate the action of the Senate to the House.
Engrossed committee substitute for Senate Bill 493, allowing creation of self-settled spendthrift trusts. Third reading of the bill.
Questions on passage of the bill. Senator from Morgan.
Thank you, Mr. President. The committee substitute for Senate Bill 493 authorizes self-settled spendthrift trusts in West Virginia. It does that by amending one section of the code, which is 44D-505, and the creation of three new sections of the code, which are located in Chapter 44D, Article 5, designated as sections 503A, 503B, and 503C. This bill came to the legislature as a recommended measure from the West Virginia State Bar's Probate Committee. And it addresses a fairly limited, narrow practice area, but in West Virginia, under current law, people can establish a spendthrift trust. A spendthrift trust essentially is a trust that doesn't allow the beneficiary of the trust to control how the money is used or expended, even though the trust is for his or her benefit. As was mentioned in committee by some of the members who have familiarity with this, this occurs often in cases where people have disabilities and aren't capable of managing their own affairs. You see it in those sorts of situations where they're set up for those individuals by other people. This allows a person as an advanced planning measure to set up a self-settled spendthrift trust, a trust for himself. And there are a bunch of many tight criteria within the bill that control and restrict how that's done and what it must do. The bill makes it clear that it can't be used to violate the West Virginia Uniform Fraudulent Transfers Act. That's current law in West Virginia in Chapter 40, Article 1A of the West Virginia Code. This permits challenges to those trusts under the Uniform Fraudulent Transfers Act. The bill addresses multiple transfers or a series of transfers, but the meat of this thing is in Section 503B, and to be able to set up and qualify as a qualified self-settled spendthrift trust as defined in the Act, the trust must be, number one, irrevocable. It can't be something that you change your mind on and terminate later. Two, it has to be created during the grantor's lifetime. Three, there must be another beneficiary whose interest in the trust is equal to that of the grantor. Four, the trust must have at least one qualified trustee, and the trust documents must expressly incorporate the laws of West Virginia to govern the validity, construction, and the administration of the trust. There must be a spendthrift provision in the trust documents. And again, that's restriction on allowing creditors to reach, grantor's creditors to reach the trust assets, or the grantor himself in some cases. And seven, the grantor does not have the right to disapprove of distributions from the trust. And then the grantor must also execute a qualified affidavit. And there's a long section of the code, subsection, that addresses what has to be in a qualified affidavit, including sworn representations that the trust assets are not derived from unlawful activities, that the grantor has the right to the property and to transfer it to the trust, that the grantor will not be rendered insolvent by doing that, that the grantor has no intention to defraud creditors by making such a transfer. 5, under oath again, that there are no pending or threatened court actions against the grantor. 6, that the grantor is involved in no administrative proceedings at the time of the transfer, and that the grantor is not subject to any outstanding orders. And this actually came as an amendment from one of the committee members, the gentleman from Harrison County, I believe, but the restriction now, the grantor not subject to any outstanding orders for alimony or child support. The committee substitute made just a few changes to the introduced bill, and those were actually, I think, all in the form of amendments to the language that came from the gentleman from Harrison County. There is language in the committee substitute now that if the qualified affidavit contains a material misstatement of fact, then that is a basis for the setting aside of the trust. And then there are the exclusions in this language for basically domestic obligations. The language in the committee substitute says, in order the court for the payment of support or alimony in favor of the transferor's spouse, former spouse, or children, or for division or distribution of property incident to a judicial proceeding with respect to a divorce or annulment in favor of such transferor's spouse or former spouse, except for any such indebtedness expressly identified in the affidavit or an attachment to the affidavit. I will be happy to try to answer questions about this, Mr. President. Otherwise, I will urge passage of the bill.
Questions on passage of the bill? Is there discussion? You handled that well, Senator. If not, the question for the Senate, shall the bill pass? All those in favor will vote yea. Those opposed vote nay. The clerk prepare the machine. Has every member voted? If so, the clerk close the machine. Ascertain the results on this question. 34 yeas, 0 nays, 0 absent, not voting. More than a majority of those present voting having voted in the affirmative declare the bill passed. Clerk will communicate the action of the Senate to the House.
Engrossed committee substitute for Senate Bill 510, establishing adult drug court participation fund. Third reading of the bill.
Questions on passage of the bill? Senior Senator from the 4th.
Yes, sir. I think I'll be able to get through this a little more briefly. This bill creates within the state treasury a special revenue fund designated the Adult Drug Court Participation Fund to be administered by the West Virginia Supreme Court of Appeals. This fund consists of monies received from individuals participating in the drug court program and is used to pay the costs associated with maintaining and administering the court's adult drug court programs. This bill actually came to us from the Supreme Court, and they said they needed this fund to make this run more smoothly, so I encourage passage of the bill.
Questions on passage of the bill? Is there discussion? Not the question for the Senate, shall the bill pass? All those in favor vote yea. Those opposed vote nay. The clerk prepare the machine. Has every member voted? If so, the clerk close the machine. Ascertain the results on this question. 34 yeas, 0 nays, 0 absent, not voting. More than a majority of those present voting having voted in the affirmative declare the bill passed. Clerk will communicate the action of the Senate to the House.
Engrossed committee substitute for Senate Bill 511, establishing court advanced technology subscription fund. Third reading of the bill.
Questions on passage of the bill? Senior Senator from the 4th.
And Mr. President, this is also a bill that came to us from the Supreme Court, and briefly here's what it does. It creates within the state treasury a special revenue fund designated the Court Advanced Technology Subscription Fund to be administered by the Supreme Court. The fund consists of monies received from users of the court's advanced technology systems, and all monies deposited into the fund shall be used to pay the cost associated with maintaining and administering the court's advanced technology systems. I urge passage of the bill.
Questions on passage of the bill? Is there discussion? If not, the question for the Senate, shall the bill pass? All those in favor will vote yea. Those opposed vote nay. The clerk will prepare the machine. Has every member voted? If so, the clerk close the machine. Ascertain the results on this question. 34 yeas, 0 nays, 0 absent, not voting. More than a majority of those present voting having voted in the affirmative declare the bill passed. The clerk will communicate the action of the Senate to the House.
Engrossed Senate Bill 516, relating to registration for selective service. Third reading of the bill.
Questions on passage of the bill? Junior Senator from the 2nd.
Thank you, Mr. President. The purpose of this bill is to bring West Virginia in line with the rest of the states that are in our selective service district. Currently, the men from over the age of 18 are required to register with the selective service, and failure to do so is in violation of the law and can subject them to penalties such as not being eligible for a state job or enrollment in state university or for student loans. Currently, now when a gentleman goes down to the selective to get a driver's license, they're requested to check a box. Many do not check the box, even though below there it says you're required to check the box if you're 18 years of age or older. So what we're doing is just the box will already be checked, so when a young man registers for a driver's license, he's registering for a selective service. This will bring our compliance rate up from around 67% to in the high 90s. I'll be glad to answer any questions. Otherwise, I urge passage of the bill.
Questions on passage of the bill. Is there discussion? If not, the question for the Senate, shall the bill pass? All those in favor vote yea. Those opposed vote nay. The clerk prepare the machine. Has every member voted? If so, the clerk close the machine. Ascertain the results on this question. 34 yeas, 0 nays, 0 absent, not voting. More than a majority of those present and voting having voted in the affirmative, I declare the bill passed. Clerk will communicate the action of the Senate to the House.
Engrossed Senate Bill 583, repealing certain obsolete legislative rules by Department of Administration. Third reading of the bill.
Questions on passage of the bill. Senator from Morgan.
Thank you, Mr. President. The originating bill, Senate Bill 583, is the first of 8 bills in a row that we're going to consider here on the floor on third reading relating to the elimination and repeal of obsolete legislative rules. And let me say a few things that will apply to this bill, but they will also apply to the other 7 that we're going to consider. And I'm sure the members will be relieved if I don't repeat this for each of the bills. The Judiciary staff started this project on eliminating obsolete regulations at the direction of the legislative leadership. We know that West Virginia has an enormous regulatory burden imposed on citizens and businesses in this state. And I think it was the President's position, gave us leadership on this, that we should, start with clearing out of our administrative code obsolete rules or duplicative rules. And so just so the membership will know what the numbers are, there are 1,842 active rules in the state register. And of those, 422 are legislative exempt, meaning they're not within the jurisdiction of the legislature or the legislative rulemaking and review process. So that leaves 1,420 active rules in the state register. Now, this particular aspect of the project focused on rules that have been in place from the period of 1946 to 1999, a lengthy period. So in cooperation, I should compliment the administration and all the agencies, because there was a high level of interest and cooperation in the executive branch of the government with this project. The Judiciary staff, the legislature staff asked agencies to review their rules and determine which ones could be completely eliminated as being obsolete, duplicated, unnecessary for whatever reason. Of the 469 active rules, during that period, the agencies reviewed 469 active rules. With respect to those, we got responses, and these bills, this 583 is the first of 8 bills that in total will repeal and strip out of our state's administrative code 125 rules that are obsolete or unnecessary. The members should know that in addition to these 125, which are not dispersed evenly among the 8 bills, some have fewer, some have more, but they add to 125 rules, there are 44 other rules that have been eliminated. This legislature last year passed changes to the Administrative Procedures Act that authorized the Secretary of State to carve out some obsolete, expired, or unnecessary rules. And to date, they have eliminated, I think, 44. So we're talking about a total, including those, of 169 rules that are being eliminated from our regulatory code. And so the first of those, Senate Bill 583, is a bundle of rules that comes from the Department of Administration, obsolete legislative rules. Be happy to try to answer questions about this bundle or the project generally. Otherwise, urge passage of Senate Bill 583.
Questions on passage of the bill. Is there discussion? If not, the question for the Senate, shall the bill pass? All those in favor vote yea. Those opposed vote nay. The clerk prepare the machine. Has every member voted? If so, the clerk close the machine and ascertain the results on this question. 34 yeas, 0 nays, 0 absent, not voting. More than a majority of those present and voting having voted in the affirmative, I declare the bill passed. Senator from Jackson.
Mr. President, I move the bill be made effective from passage and request unanimous consent that the roll call used on passage be used to make it so effective.
Senator from Jackson moves the bill be made effective from passage. Request unanimous consent that the roll call used on passage of the bill be used to make it so effective. Is there objection? Chair hears none on this question. 34 yeas, 0 nays, 0 absent, not voting. More than two-thirds of those elected to the Senate having voted in the affirmative declare the bill effective from passage. Clerk will communicate the action of the Senate to the House.
Engrossed Senate Bill 584, repealing certain obsolete legislative rules by DEP. Third reading of the bill.
Questions on passage of the bill. Senator from Morgan.
Thank you, Mr. President. Same background. This bill does exactly what the short title says, and it repeals a bundle of rules that are active rules, but they're obsolete within the Department of Environmental Protection. I urge passage of the bill.
Questions on passage of the bill. Is there discussion? If not, the question before the Senate is, shall the bill pass? All those in favor vote yea. Those opposed vote nay. The clerk prepare the machine. Has every member voted? If so, the clerk close the machine and ascertain the results. On this question, 33 yeas, 0 nays, 1 absent, not voting. More than a majority of those present and voting having voted in the affirmative, I declare the bill passed. Senator from Jackson.
Thank you, Mr. President. I move the bill be made effective from passage and request unanimous consent that the roll call used on passage be used to make it so effective.
Senator from Jackson moves the bill be made effective from passage. Request unanimous consent that the roll call used on passage of the bill be used to make it so effective. Is there objection? Chair hears none on this question. 33 yeas, 0 nays, 1 absent, not voting. More than two-thirds of those elected to the Senate having voted in the affirmative declare the bill effective from passage. Clerk will communicate the action of the Senate to the House.
Engrossed Senate Bill 585, repealing certain obsolete legislative rules by DHHR. Third of the bill.
Question is on passage of the bill. Senator from Morgan.
Thank you, Mr. President. Originating Senate Bill 585 repeals a bundle of obsolete and unnecessary rules that are all within the Department of Health and Human Resources and its various boards and agencies. I urge passage of the bill.
Questions on passage of the bill. Is there discussion? If not, the question for the Senate, shall the bill pass? All those in favor vote yea. Those opposed vote nay. The clerk prepare the machine. Has every member voted? If so, the clerk close the machine, ascertain the results on this question. 33 yeas, 0 nays, 1 absent, not voting. More than a majority of those present voting having voted in the affirmative declare the bill passed. Senator from Jackson.
Thank you, Mr. President. I move the bill be made effective for passage and request unanimous consent that the roll call used on passage be used to make it so effective.
Senator from Jackson moves the bill be made effective for passage. Request unanimous consent that the roll call used on passage of the bill be used to make it so effective. Is there objection? Chair hears none on this question. 33 yeas, 0 nays, 1 absent, not voting. More than two-thirds of those elected to the Senate having voted in the affirmative declare the bill effective for passage. Clerk will communicate the action of the Senate to the House.
Engrossed Senate Bill 586, repealing certain obsolete legislative rules by Department of Military Affairs and Public Safety. Third reading of the bill.
Questions on passage of the bill. Senator from Morgan.
Thank you, Mr. President. The engrossed originating Senate Bill 586 repeals a bundle of rules that are obsolete and unnecessary within the Department of Military Affairs and Public Safety. I urge passage of the bill.
Questions on passage of the bill. Is there discussion? If not, the question for the Senate, shall the bill pass? All those in favor vote yea. Those opposed vote nay. The clerk prepare the machine. Has every member voted? If so, the clerk will close the machine and ascertain the results. On this question, 33 yeas, 0 nays, 1 absent, not voting. More than a majority of those present and voting having voted in the affirmative declare the bill passed. Senator from Jackson.
Thank you, Mr. President. I move the bill be made effective from passage and request unanimous consent that the roll call used on passage be used to make it so effective.
Senator from Jackson moves the bill be made effective from passage. Request unanimous consent that the roll call used on passage of the bill be used to make it so effective. Is there objection? Chair hears none on this question. 33 yeas, 0 nays, 1 absent, not voting. More than two-thirds of those elected to the Senate having voted in the affirmative declare the bill effective from passage. Clerk will communicate the action of the Senate to the House.
Engrossed Senate Bill 587, repealing certain obsolete legislative rules by Department of Revenue. Third reading of the bill.
Questions on passage of the bill. Senator from Morgan.
Thank you, Mr. President. The engrossed originating Senate Bill 587 repeals a bundle of unnecessary or obsolete legislative rules from the Department of Revenue. I urge passage of the bill.
Questions on passage of the bill? Is there discussion? If not, the question for the Senate, shall the bill pass? All those in favor vote yea, those opposed vote nay. The clerk prepare the machine. Has every member voted? If so, the clerk close the machine. Ascertain the results on this question. 34 yeas, 0 nays, 0 absent, not voting. More than a majority of those present and voting having voted in the affirmative declare the bill passed. Senator from Jackson.
Thank you, Mr. President. I move the bill be made effective from passage and request unanimous consent that the roll call used on passage be used to make it so effective.
Senator from Jackson moves the bill be made effective from passage and requests unanimous consent that the roll call used on passage of the bill be used to make it so effective. Is there objection? Chair hears none on this question. 34 yeas, 0 nays, 0 absent, not voting. More than two-thirds of those elected the Senate, having voted in the affirmative, declare the bill effective from passage. Clerk will communicate the action of the Senate to the House.
Engrossed Senate Bill 588, repealing certain obsolete legislative rules by Department of Transportation. Third reading of the bill.
Questions on passage of the bill? Senator from Morgan.
Thank you, Mr. President. The engrossed originating Senate Bill 588 repeals a bundle of unnecessary or obsolete or unauthorized rules within the Department of Transportation. I urge passage.
Questions on passage of the bill? Is there discussion? If not, the question for the Senate, shall the bill pass? All those in favor vote yea, those opposed vote nay. The clerk prepare the machine. Has every member voted? If so, the clerk close the machine. Ascertain the results on this question. 34 yeas, 0 nays, 0 absent, not voting. More than a majority of those present voting having voted in the affirmative declare the bill passed. Senator from Jackson.
Thank you, Mr. President. I move the bill be made effective from passage and request unanimous consent that the roll call used on passage be used to make it so effective.
Senator from Jackson moves the bill be made effective for passage. Requests unanimous consent that the roll call used on passage of the bill be used to make it so effective. Is there objection? Chair hears none on this question. 34 yeas, 0 nays, 0 absent, not voting. More than two-thirds of those elected to the Senate having voted in the affirmative declare the bill effective from passage. Clerk will communicate the action of the Senate to the House.
Engrossed Senate Bill 589, repealing certain obsolete legislative rules by miscellaneous agencies and boards. Third reading of the bill.
Questions on passage of the bill. Senator from Morgan.
Thank you, Mr. President. Engrossed originating Senate Bill 589 repeals a bundle of rules that come from various miscellaneous boards and commissions, which rules are obsolete, unnecessary, or unauthorized. I urge passage.
Questions on passage of the bill. Is there discussion? If not, the question for the Senate, shall the bill pass? All those in favor vote yea, those opposed vote nay. Clerk prepare the machine. Has every member voted? If so, the clerk close the machine. Ascertain the results on this question. 34 yeas, 0 nays, 0 absent, not voting. More than a majority of those present voting having voted in the affirmative declare the bill passed. Senator from Jackson.
Thank you, Mr. President. I move the bill be made effective from passage and request unanimous consent that the roll call used on passage be used to make it so effective.
Senator from Jackson moves the bill be made effective for passage. Requests unanimous consent that the roll call used on passage of the bill be used to make it so effective. Is there objection? Chair hears none. On this question, 34 yeas, 0 nays, 0 absent, not voting. More than two-thirds of those elected to the Senate having voted in the affirmative declare the bill effective from passage. Clerk will communicate the action of the Senate to the House.
Engrossed Senate Bill 590, repealing certain obsolete legislative rules by Department of Commerce. Third reading of the bill.
Questions on passage of the bill. Senator from Morgan.
Thank you, Mr. President. To the members, this is the final one in this batch of repealers. Engrossed originating Senate Bill 590 repeals a bundle of rules that are obsolete, unnecessary, or unauthorized that are within the Department of Commerce. I urge passage of the bill.
Questions on passage of the bill. Is there discussion? If not, the question for the Senate, shall the bill pass? All those in favor vote yea, those opposed vote nay. The clerk prepare the machine. Has every member voted? If so, the clerk close the machine. Ascertain the results on this question. 34 yeas, 0 nays, 0 absent, not voting. More than a majority of those present and voting having voted in the affirmative declare the bill passed. Senator from Jackson.
Thank you, Mr. President. I move the bill be made effective from passage and request unanimous consent that the roll call used on passage be used to make it so effective.
Senator from Jackson moves the bill be made effective from passage. Requests unanimous consent that the roll call used on passage of the bill be used to make it so effective. Is there objection? Chair hears none on this question. 34 yeas, 0 nays, 0 absent, not voting. More than two-thirds of those elected to the Senate having voted in the affirmative declare the bill effective from passage. Clerk will communicate the action of the Senate to the House. Bills on second reading.
Committee substitute for Senate Bill 10, creating Unborn Child Protection from Dismemberment Abortion Act. Second reading of the bill.
The Senator from Ohio.
Thank you, Mr. President. I ask unanimous consent to move the bill to third reading with right to amend.
Is there objection? Chair hears none, so ordered.
Committee substitute for Senate Bill 16, providing tax credit for providing broadband service to unserved areas. Second reading of the bill.
Are there amendments to the bill?
No, sir.
Not the bill be engrossed and advanced to third reading.
Committee substitute for Senate Bill 105, creating Tim Tebow Act, allowing non-public school student participate in SSAC member school athletics. Second reading of the bill.
Are there amendments to the bill?
Yes, sir. Senator Takubo moved to amend the bill on page 1, section
The
25.
junior senator from the 17th.
Mr. President, I request unanimous consent to explain the amendment in lieu of having it read.
Junior senator from the 17th requests unanimous consent to explain the amendment in lieu of having it read. Is there objection? Chair hears none, so ordered. Junior senator from the 17th.
Thank you, Mr. President. It became aware to us that there had been a little discrepancy written in the bill. This was intended to allow homeschool students to participate in school athletics and activities for SSAC schools, both public and private. However, they had, the way the bill was written, it would essentially force private schools to accept these students into their athletics. And part of the being a charter private school, they should have the right to either participate or not. This was just kind of an oversight by everyone, and once the bill was read. So the amendment simply says that the non-public school has to agree upon its extracurricular activities of Tebow students.
Is there discussion? Senator from Preston.
Thank you, Mr. President. As described by the good senator, this is completely in agreement with the spirit of the bill, and I would support it.
Further discussion? Senator from Harrison.
Will the senator from Kanawha yield?
Will the junior senator from the 17th yield? The senator yields.
Senator, I don't quite understand. Is the effect of your amendment to not require private schools to accept, and we'll call them Tim Tebow students from wherever they come, for athletic and extracurricular activities?
That's correct. So for private schools that participate with the SSAC, them being a private school, their beliefs, and they're a little bit in a different situation because they're often completely privately funded by the parents that choose. The private schools has the option to accept or not accept, and so the concern is they are private for specific reasons. Now, I know some schools would probably welcome that, some won't, but because it is a private institution under certain principles, it was felt that they should be allowed the choice to participate or not participate, accepting those students. It would be up to the school's option.
And it's, I understand limited budgets, and I guess we have some have the same concern for public schools, that we're forcing public schools to take Tebow students without any additions to their budgets. Kind of the same thing, except we're worried about private schools because their budgets are smaller and privately funded.
Well, I would say not exactly, because the taxpayers, the children are paying those taxes regardless. Now, I understand that's not necessarily getting funded to the exact schools, but in the case of a private school, their tax dollars are obviously, they're making the choice not to take the benefit of those tax dollars for the public education, but oftentimes paying very high rates for private schools. And so the private schools' argument is that, their reputation of their students, of the way they participate is maybe affected by allowing outsiders into that. They're private for a reason, and that's the concern.
Of course, the public school systems, although taxes are paid by the parents of Tebow students to the counties and state, the public schools don't get those taxes because they don't have the student count. Can you just explain to me why we're going to protect only the private schools, who I understand don't get any extra money if Tebow students come there, but we're not going to protect the public schools who get no additional tax funds for Tebow students coming to their public school to participate in athletics and extracurricular activities?
I don't think probably the finances was the biggest concern for the private school communities. It was It was more the fact that their charter, they are selective of different students, and so they felt concerned about having other students. For example, some of these private schools may be Catholic schools, Christian schools. In fact, there was a Catholic school principal that contacted me of a private school, and so if you have outside interest coming into their school that is not consistent with their charter, their guidelines, they're afraid that that would disrupt the school. I don't think it's so much a financial as it was the integrity of what that private school is trying to accomplish.
I guess that would also run to the same argument that the public schools are taking kids that don't sign the code of conduct, don't have a GPA. They're worried that that's going to disrupt their schools too. But again, this is just the effect of your amendment is just for the private schools and parochial schools.
That's correct.
Thank you.
Is there further discussion? Senator from Campbell.
Thank you, Mr. President. Will the gentleman yield?
Senator yields. Senator yields.
Again, I want to make sure I understand this because I think I'm in full agreement with the bill and with the proposed amendment. So as I understand it, the public schools, a student that's homeschool taught would have the ability to go down to his high school or middle school within his district, and if he is talented enough, be a part of a sports team at that school, even though he's homeschooled. Is that the
That's
general
correct.
idea?
That's correct.
And that the amendment is that the folks that have their children in, when I say private schools, to me, that means Catholic schools, because that's where I grew up. But it's a variety of other schools, non-denominational schools, Lindsley Military School, whoever it might be, if they still exist. So what I'm saying is the amendment would say to those private schools, if Joe Blow from the other part of town decides he wants to be the star of your basketball team, and he just happens to be homeschooled, you got to take him. And this amendment would say, you really don't. If he wants to do that, he can go to the public school.
That's correct.
Thank you.
Further discussion? If not, the question is on the adoption of the amendment offered by the junior senator from the 17th. All those in favor will say aye. Those opposed say no. The ayes appear to have it. The ayes do have it. I declare the amendment adopted. Are there further amendments to the bill?
Yes, sir. Senator Palumbo moved to amend the bill on page 2, section 25B.
The senior senator from the 17th.
Thank you, Mr. President. I ask unanimous consent to explain the amendment in lieu of having it read.
Senior senator from the 17th requests unanimous consent to explain the amendment in lieu of having it read. Is there objection? Chair hears none, so ordered. Senior senator from the 17th.
Thank you, Mr. President. This bill also deals with allowing private, parochial, or church school students to participate in public school extracurricular activities. This amendment would make clear that they can only do that if their school does not offer the same activity. So essentially, if you're attending a private school that offers whatever the thing is, show choir, then you can't go to the public school and participate in theirs if you have that activity at your own school. And with talking with the senator from Preston, I think as far as sports goes, most private schools are governed by the SSAC, so this would not apply to them. This only applies to probably a relatively small number of schools, but it would just be a safeguard to make sure that people can't just pick and choose where they want to participate in the program, only do this if the program's not offered where they go. So I urge adoption of the amendment.
Is there discussion? Senator from Preston.
Thank you, Mr. President. Once again, I will say that although this was not considered in committee, I would say that it is not inconsistent with the spirit of the bill and would support it.
Further discussion? Senator from Harrison.
Yes, I would rise to speak in favor of the gentleman's amendment. We're, for the very same reasons that the gentleman from KENNETH's amendment to protect private schools from TBO students coming into their schools with significant disruption, the same concern arises for public schools. Many of these students will not be held to the same standards as the public school students as far as grade, conduct during the school day, and many other issues, let alone the concern of the strain on public school budgets. And I would urge passage of this amendment.
Further discussion? If not, the question is on the adoption of the amendment offered by the senior senator from the 17th. All those in favor will say aye. Those opposed say no. The ayes appear to have it. The ayes do have it. I declare the amendment adopted. Are there further amendments to the bill?
Yes, sir. Senator Romano moved to amend the bill on page 1, section 25B.
The senator from Harrison.
Mr. President, given the passage of the prior amendment, I ask for unanimous consent to withdraw the amendment presently before the body.
Is there objection? Chair hears none, so ordered. Are there further amendments to the bill?
No, sir.
If not, the bill will be engrossed and advanced third reading.
Committee substitute for Senate Bill 267, modifying removal procedure for certain county, school district, and municipal officers. Second reading of the bill.
Are there amendments to the bill?
No, sir.
If not, the bill will be engrossed and advanced third reading.
Committee substitute for Senate Bill 283, creating crime when fire is caused by operation of a clandestine drug laboratory. Second reading of the bill.
Are there amendments to the bill?
No, sir.
If not, the bill will be engrossed and advanced third reading.
Committee substitute for Senate Bill 313, relating to school calendar and allowing limited use of available accrued instructional time.
Senator from Preston.
Thank you, Mr. President. I ask unanimous consent that the Senate Bill 313 lie over one day and retain its place on the calendar.
Is there objection? Chair hears none, so ordered.
Senate Bill 351, dedicating severance tax proceeds. Second reading of the bill.
Are there amendments to the bill?
No, sir.
If not, the bill be engrossed and advanced third reading.
Senate Bill 356, eliminating consumer sales and service tax exemption for 2016 fiscal year. Second reading of the bill.
Are there amendments to the bill?
No, sir.
If not, the bill be engrossed and advanced third reading.
Committee substitute for Senate Bill 400, reducing amount of sales tax proceeds dedicated to school major improvement fund. Second reading of the
Are
bill.
there amendments to the bill?
No, sir.
If not, the bill be engrossed and advanced third reading.
Committee substitute for Senate Bill 424, allowing fire departments assess fees.
The senator from Jackson.
Thank you, Mr. President. I ask unanimous consent that the bill lie over one day, retaining its place on the calendar.
Is there objection? Chair hears none, so ordered.
Committee substitute for Senate Bill 436, defining adequate shelter for dogs and cats. Second reading of the bill.
Are there amendments to the bill?
No, sir.
If not, the bill be engrossed and advanced third reading.
Senate Bill 439, eliminating requirement that budget director approve requisitions for personal services payment under certain circumstances. Second reading of the bill.
Are there amendments to the bill?
No, sir.
If not, the bill be engrossed and advanced third reading.
Senate Bill 462, reducing deposit of excess lottery proceeds into West Virginia Infrastructure Fund. Second reading of the bill.
Are there amendments to the bill?
No, sir.
If not, the bill be engrossed and advanced third reading.
Committee substitute for Senate Bill 504, relating to confidentiality of juvenile records. Second reading of the
Are
bill.
there amendments to the bill?
No, sir.
If not, the bill will be engrossed and advanced third reading.
Senate Bill 507, exempting motor vehicles engaged in non-emergency transport of Medicaid recipients from PSC permit requirements. Second reading of the bill.
Are there amendments to the bill?
No, sir.
If not, the bill be engrossed and advanced third reading.
Senate Bill 515, authorizing payment of certain claims against states. Second reading of the bill.
Are there amendments to the bill?
No, sir.
If not, the bill be engrossed and advanced third reading. Bills on first reading. Senator from Jackson.
Thank you, Mr. President. I request unanimous consent that all bills on first reading be considered as having been read a first time and advanced to second reading.
Senator from Jackson.
Thank you, Mr. President. I ask unanimous consent to withdraw my unanimous consent request.
Is there objection? Chair hears none. Bills on first reading.
Committee substitute for committee substitute for Senate Bill 315, providing for construction of statewide fiber optic broadband infrastructure network. First reading of the bill.
Bill be advanced second reading.
Committee substitute for Senate Bill 529, making certain sport and educational fantasy games lawful. First reading of the bill.
The senator from Morgan.
Thank you, Mr. President. I move that the committee substitute for Senate Bill 529 be referred to the Committee on Finance for its consideration.
The senator from Morgan moves that Senate Bill, the committee substitute for Senate Bill 529 be referred to the Committee on Finance. Is there discussion? Senator from Cabell.
Will the gentleman yield?
Will the senator from Morgan yield? Senator yields.
Yes.
Is this the fantasy football bill?
It is.
And the one that we spent considerable time on Friday in our committee?
It is the one and the same.
And I try to pay attention at all times, but is the motion to refer this to the Finance Committee?
Yes, sir.
And could you explain why?
It was suggested to me after our committee meeting that although this bill likely in its current form does not have any financial impact upon the state, that the other states are licensing those in fantasy game endeavors, and so the suggestion was that if there is to be, that the bill actually ought to be considered in the Finance Committee for them to determine whether or not and how, if so, any sort of state registration or licensing should occur.
Well, by state registration and licensure, we mean revenue, right?
Potentially, that could be.
And if the FanDuel or DraftKings decided they didn't want to pay the revenue, then they wouldn't be permitted to do business in West Virginia. Would that sort of be the option they'd have?
Well, to my good friend from Cabell County, you're going to have a hard time finding anybody who's lower tech around here than I am. As we learned in committee, the domiciles of those organizations are states other than West Virginia. So I don't know the answer to that question.
Well, the reason I raise the question is there's a likelihood that, or there's a possibility that the Wheeling area might eventually be the beneficiary of job movement by one of those two companies from New York, where they've been repudiated, and they may be considering the movement of some jobs into our state. So I think we should be careful not to. I think we should be considerate of that issue before we decide we want to extract $500,000 or $1 million or whatever numbers I've heard thrown around to ask them to do business in our state. I just think we should be mindful of all the circumstances before we just think here's another couple of corporations that we might be able to shake down for some easy cash.
Well, I appreciate the gentleman bringing up the issue on the floor, and I agree with the gentleman, and my supposition, I was going to say my bet, but I thought that would be
it's not betting, it's a game of skill.
That my bet would be that the members of the Finance Committee are also going to be delighted to hear the information that the gentleman has brought to the attention of the members, and will be mindful of that in their consideration of what, if anything, they should do in the way of changes or reporting this bill.
Thank you so much.
Thank you.
Further discussion. Senator from Jefferson.
The Judiciary Chair yield.
Senator from Morgan yield. He
Happily.
absolutely will.
Mr. Chairman, is this the first time you've heard of the possible jobs that one of these companies might move to West Virginia? We
Absolutely.
did not hear that in committee.
Absolutely.
We didn't hear that in committee, did we?
No, I have not, and I can't think of anything that would be more exciting news. That would be very exciting news.
Yeah. If that's a possibility. But in addition, I had asked the chairman, even during the meeting when we wrapped this bill up, testimony in committee was that there are about 300,000 West Virginians out of 1.8 million, about 300,000 that apparently currently do this, play these games, and there's money involved. And my request to the Judiciary Chair was how much money is involved in those 300,000 people. Do we have any idea on that?
I do not, but that is embraced within the thought of my motion, which is to let the Finance Committee at least consider it and look at the
Great.
legislation.
And, because I do think that's important to the chairman and also to the president, that we need a barometer as it goes to the Finance Committee, and I'm wholeheartedly supportive of that, but how much money are we talking about? In committee, it was about $1, $2, $3 per bet. If that's 300,000 people times just a couple dollars, but if it's a lot of revenue, and we're authorizing this new type of gambling, sanctioning it, in other words, we ought to have some concept of how much money is involved in this, and I hope that the Finance Committee can answer that question that was raised and unanswered in the Judiciary Committee. Thank you, Mr. President.
Is there further discussion? Further discussion? Senator from Cabell.
I'd like to speak in opposition to the motion. We had some fairly weighty legislation that went through here. I guess was that last week that we didn't double reference. And the average bet, I think, in West Virginia is, the average skill attempt, because it's not gambling, was $3. I think the gentleman that came to us from Spillman Thomas that spoke to the committee, he invests about $3 a week on that, and apparently many thousands of our citizens enjoy this activity that the young people know very well, but the old gray-haired people seem puzzled about. So, Mr. President, you may agree with me finally. Why do we need to regulate and tax these out-of-state corporations every chance we get? Thank you.
Further discussion. The senator from Ohio.
Thank you, Mr. President. I'm going to join my colleague across the aisle here from CABELL in speaking against the motion. We had considerable debate on this issue, on this very topic of whether or not this bill should be debated by the Finance Committee, and ultimately it was the will of the committee to say that we do not want to be over-regulating an industry. And as my friend from CABELL mentioned today, the opportunity for additional jobs in our state, which we desperately need. So for that reason, I'm going to speak against the motion.
Is further discussion? Is there further discussion? If not, the question before the Senate. Who requested a yeas and the nays? Senator from Cabell requests the yeas and the nays. Is there objection? Chair hears none. So ordered. The question before the Senate is the adoption of the motion by the Senator from Morgan to refer committee substitute for Senate Bill 529 to the Committee on Finance. The Senator from Jackson.
Thank you, Mr. President. Just a quick clarification. If you do not...
Was that point of order? Did you?
Yeah, point of order, Mr. President.
State your point.
Just so I'm clear on this and the members are clear, a no vote on this would not refer this bill to finance. A yes vote would refer it to finance. So this clarification, if you do not feel that this should go to the Finance Committee, you would vote no.
So that was a point of inquiry. Do you want to state that again, please? Okay. All right, question for the Senate is the adoption of the motion to refer the committee substitute for Senate Bill 529, refer to the Committee on Finance. All those in favor will vote yea. Those opposed will vote nay. The clerk will prepare the machine. Has every member voted? If so, the clerk will close the machine and ascertain the results. On this question, 16 yeas, 18 nays, 0 absent, not voting, less than a majority of those present voting having voted in the affirmative, I declare the motion rejected. The bill be advanced to second reading. Introduction of guests. Senior Senator from the 4th.
In the, what gallery is that one? The rear gallery. In the rear gallery is my lovely wife of many years, which I will not state if she would stand, and the Senate mate, Vicki Hall. Welcome to the chamber today.
Further introductions. Senator from Ohio.
Thank you, Mr. President. In the gallery to my right here, we have a number of folks. The Senator from Brooke and I would like to welcome to the Senate today. There's several horsemen and horsewomen from Hancock County, and I just want to make a note that they contribute greatly to our economy based on tourism and agriculture. They are Brady Howe, Jamie Poole, John Baird, Jennifer Johnson, Janet Tetrault, Annette McCoy, Bart Baird, and Michelle Porter. If they would please stand, which they are, and the Senate please make them welcome.
Further introductions. Remarks by members. Senator from Marshall.
Thank you, Mr. President. I will be brief, but I just wanted to point out during the petitions that we did file a petition on behalf of the AFT West Virginia, affiliated with the AFL-CIO, of 4,710 people who signed a petition on the Action Network asking us to fix PEIA, and it's certainly an important issue to those retirees and state employees, and I'm hopeful that we'll be able to address that in short order. Thank you, Mr. President.
Sir, further remarks by members. Miscellaneous business. Senator from Jackson.
Thank you, Mr. President. Subject to announcements, I move the Senate stand adjourned until 11 a.m. tomorrow morning.
Are there announcements? Senior Senator from the 4th.
Finance Committee will meet at 3:15. Please note the time change, and we have the agenda posted. Also, the finance members, Republican members, will caucus in finance room at about 10 till 1.
Senator from Preston.
Thank you, Mr. President. Your Committee on Education will meet today at 2:15, 451 M.
Senator from Morgan.
Thank you, Mr. President. Your Committee on the Judiciary will meet today at 3 p.m. in the West Wing.
Senator from Ohio.
Thank you, Mr. President. Your Committee on Health and Human Resources will meet today at 1:15, and the Republican members of that committee will be caucusing in the Finance Committee conference room right off of the committee room at 1 o'clock. Republican members at 1.
Senior Senator from the 15th.
Thank you, Mr. President. Your Committee on Government Organization will meet today at 2:15.
Senator from Nicholas.
Thank you, Mr. President. Your Committee on Energy, Industry, and Mining has a time change. We will be meeting at 1:30 p.m. this afternoon, room 208 West.
Junior Senator from the 8th.
Thank you, Mr. President. I know it'll be a huge disappointment, but there will be no Interstate Cooperation Committee meeting tomorrow. There will be a pensions meeting at 2 p.m. tomorrow, 208 West.
Senator from Upshur.
Thank you, Mr. President. Your Committee on Natural Resources will meet tomorrow at 2 p.m. and 451 M.
Junior Senator from the 17th.
Thank you, Mr. President. Your Committee on Economic Development will not meet. I repeat, will not meet tomorrow.
Senator from Marshall.
Thank you, Mr. President. Your Democrat caucus will meet 15 minutes after the close of the floor session in 330 W.
Further announcements. Further announcements. If not, the question for the Senate stand adjourned until tomorrow at 11 a.m. All those in favor say aye. Those opposed say no. The ayes have it. I declare the Senate adjourned.
And that concludes today's broadcast of the West Virginia Legislature on the West Virginia Channel. The House Education Committee is holding a public hearing Wednesday morning at 9 in the House chamber. At issue is House Bill 4310 to help ensure the continuing viability and vitality of West Virginia University Institute of Technology by providing flexibility to West Virginia University and WVU Tech to relocate from Montgomery to Beckley. We will provide live coverage of that public hearing tomorrow morning at 9. This concludes today's broadcast of the West Virginia Legislature on the West Virginia Channel. Audio of legislative committee meetings is available on the West Virginia Legislature's website. This program reminder, the Legislature Today, our nightly broadcast of legislative news and information, airs at 6:30 and 11:30 every weeknight on West Virginia PBS. The program also can be heard on public radio, weeknights at 6:30. The Legislature Today is repeated weeknights at 10 and weekday mornings at 6:30 here on the West Virginia Channel. I'm Beth Voorhees for the West Virginia Channel, a service of West Virginia Public Broadcasting.